Good morning, everyone. This is the Court of Appeals sitting in Bermuda on Thursday, the 4th of March, 2021. We are sitting for criminal appeal number 6 of 2020, which is Omar Davy against the Queen. Ms. Elizabeth Christopher for the Legal Aid Office is representing the appellant, Mr. Davy, and Mr. Adam Richards and Javon Rogers from the Office of the Director of Public Prosecutions for the respondent. These proceedings are taken before my lords, the President, Sir Christopher Clark, Mr. Justice Jeffrey Bell, and Mr. Justice Anthony Smelly.
Good morning. Thank you all for being here at what for you is slightly earlier than usual, and for me slightly later than usual. We will sit for the first half for the next 3 hours, but we'll probably have a 5 or 10 minute break in 2 hours' time, if that is suitable. Yes, Miss Christopher. I think you're...
I appear on behalf of the appellant, Mr. Davy, who's not yet here from what I can see.
Oh, isn't he? I'm so sorry. Oh, right.
He was, I think. I saw him a second ago.
No, those were two prison officers, and I see a prison officer in the
Oh, I
appellant.
see, you're quite right.
Yes, good morning. Yeah, he's on his way here now.
Well, we better wait for him to arrive.
Where are they getting him from, his cell?
Not quite sure why they couldn't have got him on time. Ah, right. Okay, we can start.
Yes, I appear on behalf of the appellant, Mr. Davy. My learned friends, Mr. Richards and Mr. Rogers, appear on behalf of the respondent. The court should have my written submissions done on the 4th.
Thank you.
On the 4th of January, 2020, which I think was before there was a formal record produced. So my numbering isn't identical to the record, unfortunately. And it's followed by my learned friends' submissions. Yes. I did quickly send an email with Franks and Furbett to deal with the very subsidiary point to my learned friends' submissions, if we get that far.
Right.
All right. The submissions of the appellant are not wildly different from those submitted in the application for leave, which was granted on the 20th of November, 2020. Mm-hmm. At the crux, our position is that the appellant didn't have adequate time to prepare for his trial, and had he had adequate time with counsel, properly instructed.
The appellant or the appellant's counsel, Ms. Christopher? I mean,
the appellant didn't have
adequate time. Mr. Warner was his third counsel, as I recall.
That's correct. But part of the complaint that Mr. Davy was making was that he wasn't effectively having FaceTime with his counsel especially his immediately previous counsel, in order to take proper instructions, or in order to give proper instructions. So he did have a counsel that was prepared to put in the FaceTime, but unfortunately, there wasn't really adequate time for him to be properly advised, is our submission with respect to the legal
Well,
position.
I'm not sure that's right, insofar as Mr. Richardson said that he had given certain advice to the appellant, and the judge drew the conclusion that the appellant hadn't liked the advice he'd been given.
It's my submission that at its root, in order to build a relationship of trust with the defendant, there has to be communication between the appellant and his counsel, and just a telephone conversation, if that's what it was, because it wasn't certainly face to face, to give the advice of that nature at the last moment, we respectfully submit, isn't what is intended by way of permitting a defendant to give proper instructions and to understand the advice. And
Give me the sequence of events. There are three counsel. Who was the first counsel?
Ms. Mulligan,
Miss Mulligan. And when did she cease to be counsel?
I don't have that date to hand.
Oh, then it was Mr. Richardson.
Yeah, Mr. Richardson was his counsel for a substantial period of time. I believe Ms. Mulligan's tenure, and this is only from my association working with Ms. Mulligan, might have been in the order of a few months.
Hmm.
Now, how do you say any of this is relevant now?
I simply say that had he understood the law, which I think is very, very clear with respect to the defense of duress in this jurisdiction, he would not have persisted in his not guilty plea, but he would have decided to approach the matter in a different fashion. And the eventual ruling.
Meaning he would have pled guilty?
Correct. Had he known that he had no defense, which he had no defense.
Well, if you look at the record of appeal at page 72, Mr. Richardson did give the appellant, quote, certain advice.
What page is this, Judge?
72.
Yes, I see that. The only thing I can say in that respect is there was no relationship of trust. So, and there's no absolute clarity from the face of this what that advice was. But
Agreed.
we can infer, I suppose. But the fact is, he had by that stage built up a relationship of trust with his client. Shut this phone off. Oh, the phone's on silent, but it rings through my computer,
Yep.
which I'm going to figure out a way to fix that. So effectively, that's our position, is that he had no relationship of trust. So
With Mr. Richardson, though.
correct,
So he then changed to Mr. Warner.
correct. And of course, he would by that time have had the juxtaposition of somebody with whom he didn't have the relationship of trust giving him one set of advice, and then a relationship with somebody who he quickly established, because there were lines of communication that were open, that he quickly established a relationship of trust, and thus he forged ahead with what he thought was the correct course.
Sorry, So you say he had no relationship of trust with Mr. Richardson,
Correct.
but acquired one with Mr. Warner.
Correct.
Right. But he'd had Mr. Richardson for quite a time, is that right?
Yes, but I don't understand Mr. Richardson to have seen him at Westgate or the like, and
Is that-
had communicated
That
at the
pandemic
last moment.
affected?
The appellant seems to be gesturing. I haven't let clear what he wishes to say, if anything.
Ms. Christopher, would you like to have a breakout room if your client wishes to confer with you?
Yes.
Miss Christopher? Hello?
Yes, hi.
What I want to
No,
help.
Oh,
Garrett, here.
1 minute. No, you're waiting. We're waiting for our own room to be dealt with by the clerk.
Okay, you should see a prompt, Ms. Christopher, to allow you to go into the client breakout room. DL Builder, you'd need to
Shall we go into breakout room or is...
Well, if we do, there's a day. Are there two separate ones, Mr. Coelho?
there are. Your room is still active, so if you should have the option to go to breakout room in the lower right-hand corner.
Well, shall we do that, but call us back as soon as...
No,
It is Christopher's back.
return.
Yes, he basically wanted to clarify for the purposes of the court that he had Mr. Richardson from September prior to the trial date. And there was no contact established until the 9th of February, which was 2 days before the trial date. Despite Mr. Davy's attempts to call him.
Mr. Davies of the prison?
Pardon me, sir? He was in
Yes.
prison, yes, sir.
Yes, thank you.
That's 9th of February 2019.
Yes, sir. Right. So going to paragraph 2 of my written submissions, Mr. Warner, who eventually was the appellant's attorney at trial, had a very short period of time in which to prepare for the trial. He came up to the record on the 11th of February, but had only first established communication with the appellant on the 9th of February in the afternoon, which is illustrated at the record on page, I believe, '75 of the, which is in the transcript, page 75 of the record.
He said, Mr. Warner says he first consulted with his client on Saturday afternoon.
Correct.
see, yes. Friday was the 9th, was it?
Yes.
Yes, sir. I believe Friday would have been Saturday would have been the 9th.
Oh,
Because it came onto the record on the 11th.
Yes. That being the date on which the trial was originally scheduled to start.
Yes. And in point of fact, Mr. Warner made clear what he had indicated to the defendant, which is that he wouldn't even enter onto the record unless he can get an adjournment. I think he was asking for an adjournment in the order of a week and received an adjournment in the order of a few days.
3 days.
3 days. And I do refer to the conversation between the appellant and the court, which is at pages, I believe, 85 to 86 of the record. Wherein Mr. Davy was effectively telling the court then what he's telling this court now. And notably, Mr. Warner echoed that at page 86 of the record, where it says, "My lord, what he is trying to reinforce with your lordship is that Mr. Richardson never since July came to Westgate to hear his story, for him to tell him his side of the story. I have already told him that your lordship had retorted on that matter by saying it was his duty to contact Mr. Richardson, which I already have addressed with your lordship. But the position with respect to that is when you're in prison, you don't have too much control whether the other person picks up the other end of the phone."
So can I just understand the sequence? Mr. Richardson is the appellant's counsel actually since July, not September.
Well, I believe September might have been the date that the trial was set for February.
Well, no, I know, but what Mr. Warner says at page 86 of the record, Mr. Richardson never since July came to Westgate to hear his story.
Yes, well, taking instructions from Mr. Davy, what he indicated is that it was September. That September might have been the date the trial was set until the date. I can't speak with clarity. I don't have the Supreme Court record.
Yeah, well, never mind. Whether it's July or September, Richardson is his counsel for several months. He doesn't actually see him until Friday the 8th and Saturday the 9th. Trial's due to begin on Monday the 11th.
Yes, I don't believe he actually saw him. I believe he had a telephone conversation, which Mr. Davy is nodding in affirmation.
Right. So there's a telephone conversation on presumably the 8th and Friday the 8th and the 9th. Mr. Richardson gives some advice, which the appellant finds unacceptable. And somehow Mr. Warner is brought in so that both Richardson and Warner are there on the Monday.
Yes.
Yeah, I see. Thank you. Mm-hmm.
I have in my submissions, the court even proffered that perhaps the appellant's previous counsel had not lived up to his duty and expressed regret that he was no longer in the face of the court. In the event, after the application for adjournment, the court decided to start the trial and the evidence on the 14th of February. So that was, as I indicated, a very short time within which for Mr. Warner to prepare.
Does that mean that Mr. Richardson was in fact not at court on the 11th?
He came at the 11th, but stated his piece,
He was excused by the judge.
which was to do with saying that he had given certain advice which wasn't accepted and was released.
I see.
So when much of the substance of the adjournment application was undertaken, he was not present.
Yes.
So as I indicated, my submission of paragraph 3 is that there's a limit to which a criminal defendant can have his attorney come to terms with his case. And in those circumstances, he is not the author of his misfortune. And certainly the discussion in the face of the court down below does not reflect an assurance that the appellant's earlier attorney had fully addressed his case. Paragraph 4, this is alluding basically to the conduct by Mr. Davy of his trial. And we are submitting simply that he made, once they were in trial mode, he made every effort to reduce the effort that was put into the trial to an absolute minimum and restrict himself to the hub of his case. His evidence was not insubstantial, but he believed that his evidence would mean something. And it's at pages 38 to 173 of the transcript. In that evidence, he alluded to having been the recipient of violence and that he had committed the offenses due to threats to his family. Effectively, he was averring that he had committed the offenses due to duress. And the duress, the species of duress is referring to is at paragraphs 47 and 48 of the criminal code. So thereafter in my submissions, I simply set those provisions out.
And how do you say that the appellant's case falls within those sections?
Well, we say that the appellant's case clearly does not fall within either of those provisions because in respect of violence, it has to be done in resistance to actual violence threatened to him or to another person in his presence. So in respect of this instance, he was referring to threats to his family, and he has a young daughter, but that was not, she was not in his presence when these threats were being made.
So doesn't it follow that the notion that he should plead guilty? Well, you say he should have been advised that there was no merit whatsoever to a defense under sections 47 and 48, and therefore he should have pleaded guilty.
Yes, by a lawyer with whom he did not receive that from any lawyer with whom he had built a relationship of trust.
Well, just a minute.
Yes,
You're going on with reference to Mr. Richardson, but he had Mr. Warner. Now, granted, it was a short time, but Mr. Warner had met with him on the Saturday,
yes, my lord.
on the Monday, and then had 3 full days within which to prepare.
Yes, and under those circumstances, the advice should have been that he had no defense.
But how do we know that that advice wasn't given? Why should we assume it wasn't?
The appellant says that it wasn't, and Mr. Warner was given an opportunity to say that it was, and hasn't. And if you look at the tone and the nature of the submissions that he made, it actually, I thought, portrayed a genuine belief in the I don't think he was trying to mislead the court, Mr. Warner. I think he honestly felt that he had a leg to stand on in respect of this defense, and I don't believe that he would have put it had he thought that the defendant had no prospects of success.
Well, that suggests that Mr. Warner did think that the defendant had prospects of success.
I believe that he did. I don't see why he would have done otherwise. Then permitted Mr. Davy to put the case that he put. However, we say that in that respect, Mr. Warner was wholly wrong.
Well, wait a moment. There are
Okay.
two different questions. As I have understood it, Mr. Davy had two different threats in effect made against him.
Yes.
One was that violence would be done to him,
Yes.
and the other was that violence would be given to his family in Jamaica.
Correct. So I already alluded to paragraph 47, which puts paid to the violence done to his family in Jamaica.
Yes.
Section 48 suggests that in order to relieve a person of criminal liability, the person who would inflict or execute the threat has actually to be physically present. And it's my submission that the person who made the threat was not physically present. So that limb didn't succeed either.
Yes, 48 doesn't work because he wasn't being threatened with death or bodily harm by some person who was actually present.
Correct.
47 doesn't work in relation to the threat to injure his wife and child because there was no actual violence threatened to them in his presence. Yes, there was, yeah, that's right. There was no violence threatened to his family in his presence.
In the presence of the family member.
Yeah, yes, right, yeah. Quite, sorry, I'm being slow. So
it takes a while to
wander
through this. Yes, it does. Great.
Yes, it has to be to another person in the presence of that other person.
Yes, my lord.
But then one has the first bit, which is for the purpose of resisting actual violence threatened to him. And in relation to that, if we go to the summing up at page 307 of the record, the learned judge he sets out at 307 the effect of section 54 and he there's somewhere, I'm sorry, I missed it, where the judge appears to leave open to the jury the possibility that the appellant imported the drugs for the purpose of resisting a continuing threat of violence to him in the future. Yes, so sorry. Go back to page 306. So this defense is it was violence actually threatened to him, or when he said that they were threatening to kill him, right, or to his mother and daughter. The law says they have to be in his presence for it to be a defense. So that's in the appellant's presence. And you know in this evidence that they were not in his presence, that's the appellant's presence, at the time of the threats. And even and after, even if you consider, as Mr. Warner says, that the threat, he was still operating under the threat. So the judge, and he then sets out the section. The judge is leaving open to the jury, as I read it, the possibility that the drugs were imported for the purpose of resisting a continuing threat of violence on the appellant in the future. And that was his case.
The only quick response I could have to that is that part of the defense of duress is that once you have an opportunity to walk away from the situation, or once you're no longer in the presence of the person making the threat, and you have the ability to do otherwise, albeit you have previously been threatened, then the threat is no longer extant.
So under section 48, in relation to...
Sorry. Let me move this. Sorry, I'm just going to move this phone to another room because I haven't succeeded in shutting it off and it's ringing again. 1 moment.
So in relation to section 48,
I think we've lost Ms. Christopher.
I've got a picture of a sunset instead.
I think she's going to turn her phone off, so she's going away from the camera.
Sorry, I've moved my phone away so it no longer rings on my computer. Hopefully it's far enough away. Sorry, what was the court saying?
Justice Bell was
Saying that in relation to section 48, the position no doubt was that by the time that the appellant reached Bermuda, he was no longer under duress.
Correct.
And that's
so, Ms. Christopher.
something on which he could have been advised.
This appeal. Sorry.
Pardon me, Mr. Justice Smelly? Did you speak?
I may have spoken across Justice Bell.
Well, I just said that's fairly basic advice which could have been given to him by Mr. Warner.
Correct.
Yeah. And I was about to comment that for the purposes of this appeal against sentence, the complaint is not that his defense wasn't properly put, but that he should have been told he didn't have a proper defense.
Correct.
Is that the complaint?
Yes.
And where is it made clear that this complaint of the failing on the part of Mr. Warner was brought to his attention so that he could comment on it?
I'm not sure. Let me see whether it's in. I did serve Mr. Warner with a copy of the affidavit that we had filed in support of the application for leave to appeal against sentence. I served him with the grounds of appeal, the order granting the leave to appeal, and I believe that Mr. Warner was given until December in order to respond.
And he
Even,
chose not to.
yes, he chose not to.
I see.
He was served both before the application for leave and then subsequent to the application. So I believe to some extent we've dealt with paragraph 6 of my submission. Going on to paragraph 7, this is page 3 of the submissions bundle. On the 18th of February, at the conclusion of evidence and prior to the parties giving their speeches, the judge solicited the parties' opinions on the law appropriate for what would be his closing. And that discussion is at pages 228 to 267 of the transcript. Where I thought Mr. Richards and the court were quite illuminating, I guess, to what the position with the law is. At this time, I write, the Crown emphasized that unlike the Queensland law, which had subsequently been amended, our local statute law restricted the defense of duress by requiring third parties to be present at the time of the threat. It was observed that counsel for the appellant took a different view. I write here, and my learned friend, I'm not sure, agrees with me, it appears that the defendant's counsel was relying more on the common law of duress, which he could not rely upon, on the local authority of Zigelis. However, there having been statute law, the appellant's counsel cannot then supplant it with common law. That's why I sent the case of Franks and Furbitz along this morning. If there needs to be a discussion of that. Furthermore, the case of Zigelis is singularly unhelpful to the appellant. It considered both sections 47 and 48. The trial judge had correctly emphasized that it is for the Crown to disprove the defense of duress. At paragraphs 11 to 13, the appellant's counsel herein asserts that in his presence must asserted, that's Mr. Warner, that in his presence must be taken to mean associated with him and was not restricted to physical presence. And that's at page 238, lines 16 to 21 of the transcript, asserting that the trial judge in Zigelis had not made that distinction. However, the case of Zigelis dealt with the very form of duress that the appellant was relying most heavily upon at paragraph 16, wherein it states, the judge gave a detailed further direction on the terms and application of section 47. The burden was on the prosecution to prove that the violence was not threatened to the defendant, his family were not present, and so that part of the section fell away. So it's my submission that, so I did include the case of Zigelis in my authorities bundle. page 1. This
So
is
you're
the-
saying that the judge got it right, Mr. Warner got it wrong.
Correct. But Mr. Warner was steadfast in insisting that he felt that he had a defense. I don't understand how it could be sustained. So in the case of Zigelis, the appellant, a Latvian national, was convicted of 6 offenses, including importation into Bermuda and possession of a controlled drug, cocaine, and of a firearm with ammunition. And after trial, was convicted, received 25 years imprisonment. He was sailing single-handedly a boat named Arthurs, which arrived in Bermuda in St. George's on the 21st of July, 2011. He told the harbor and customs authorities that the boat was not carrying prohibited drugs or firearms, and signed declarations to that effect, saying the boat needed repairs and these were begun. 11 days later, on the 1st of August 2011, police and customs discovered in the boat first a total of 166 packages, which were found to contain 164.13 kilograms of cocaine with a value in Bermuda of 17 million and 48 million, depending on how it was marketed. And secondly, a 9mm Beretta semi-automatic pistol with 2 magazines and boxes of ammunition. If you go to paragraph 9 of the judgment, at the trial, the appellant raised a defense of duress or compulsion or extraordinary emergency based on threats that he said were made to him following his discovery of the drugs in the course of the voyage, coupled with the boat's need for repairs following the storm. The judge quoted his evidence as follows: both his life and his family's life were threatened. They were going to be killed. He knew that boss he was dealing with, a man of connections wide and far with suspicious wealth. This was a serious matter. He believed that he and his family would be killed, and that is the belief that dwelt with him from the moment of that and remains up to this day. It is the reason why, even now, he will not disclose any name or any place to find anybody. So acting under that belief, he continued his journey, even in the midst of a storm and a damaged boat. So great was his fear for his life at the hands of his boss and for the life of his family at the hands of his boss. He could not take the opportunity to withdraw. Now, this is the point that I was making to the president. Even when it was presented, he never intended to import any drugs and firearms into Bermuda, but he did so of necessity and fear. And then if you look at paragraph 11, it deals with section 47, paragraph 12. And it says the judge directed the judge that the onus was on the prosecution to prove A, that violence was not threatened to the defendant at all, or to another person who was in his presence, or that the act or omission done by the defendant was not reasonably necessary in order to resist the threatened violence. And section 48 provided that the foregoing provision of this section shall not have effect. Oh, sorry, that's just reading. It also, he dealt with section 48. The judge directed the jury that the onus was on the prosecution to prove A, that no threat or death or serious harm was made to the defendant, or that the person making the threat was not present or in a position to carry it out, and that the defendant had failed to avail himself of some opportunity which was reasonably open to him to render the threat ineffective. In addition to these 3 statutory defenses, the judge said this about a possible 4th defense, which would arise if it was accepted as it should be, that the drugs were never meant to come to Bermuda, and then he deals with that issue. And then going over to paragraph 16, the judge gave a detailed further direction on the terms and application of section 47. The burden was on the prosecution to prove that the violence was not threatened to the defendant. His family were not present, and so that part of the section fell away. And if it was that the act done by the defendant was not reasonably necessary in order to resist the threatened violence, the prosecution alleged that he was not compelled to bring the drugs into Bermuda. Many other options were open to him. Again, section 48 was read out in full, pointing out that it required a threat of immediate death or grievous bodily harm made by a person who was actually present, and moreover, that the prosecution could rely on the proviso if, as they alleged, he was involved in the loading of the drugs on board his vessel and party to his agreement to carry them to Latvia. And then it goes on. I'll go on. He reminded the jury that the burden of proof was on the prosecution. So they're saying this defense, even though he raised it, is not available to him because they have disproved it. Furthermore, he reminded them that the prosecution was relying on proviso C, which he quoted. He then directed the jury to consider each of the sections in turn, and that any one of them could justify an acquittal. So the prosecution has to prove all the defenses before you can convict him. And then paragraph 22, apart from that specific matter, it was not clear to the court what misdirection was alleged in relation to any of the three individual sections. In our judgment, the judge's directions on the three defenses based on 39, 47, and 48 were entirely correct. And there was ample evidence supporting the jury's conclusion that none of the sections provided defense in the circumstances. And so we say that having looked at the case of Zigalis, or had he looked at the case, he had looked at the case of Zigalis.
He being who, Mr. Warner?
Yes, my word.
Yeah.
It should have been apparent that no defense was afforded to the appellant. And it seemed to me to some extent that Mr. Warner was trying to rely on Zigalis as saying somehow it left something open, but it's unclear to me what that would be.
Well, Zigalis and the terms of section 48, and indeed probably 47, show that there was no defense that there was a threat to his family, because 48 requires a threat of death or harm to be inflicted on him by some person actually present and in a position to execute the threats, and is actually dealing with threats against the defendant himself as opposed to his family. So 48 doesn't work. 47 deals with threatened violence to him. And as I say, it seemed to me that the judge left open the possibility that the importation was for the purpose of resisting violence threatened to him. In relation to violence against his family, violence wasn't threatened to his family in his presence, because the family weren't in his presence when any threat was made, unless you adopted Mr. Warner's somewhat rococo idea that in his presence means having some form of association with him, which is adventurous. But there was a defense available that he did what he did, namely import, to avoid the threat made to him.
Right, but once the person making the threats is no longer in his presence, the threat is not extant, we say. Any offense, once you have the ability, we say, to do otherwise than execute what you're being threatened to do, it is not extant once he was sent on his way, we say, to deliver these packages.
You say, in other words, he could have sought the protection of the law enforcement in Bermuda.
Correct. Instead of making the choice to run away. Correct. That's the key matter. that is what he could do, and that's how he was prevented from running a defense of that nature. And, you know, style of the particular trial judge's summing up is to give and take away. So I haven't seen, I see what the court is referring to on page, I have to look and see, on page 206, I believe the court said, but I feel quite certain that if I looked hard enough, I could figure out where it was taken away. No, it's not page 206, was it 236? Sorry, the learned president was had referred me to a section.
It's the bottom of page 306, going to the top of page 307.
306, correct, yes. Maybe after a break, I can probably point to where that was given, but that was then taken away.
Right.
You say it was given at 2:06?
306, sir.
306.
3:06. Right.
Indeed, in my submissions, I write the cases against provides a clear guidance of how to deal with the situation that the appellant confronted. The Court of Appeal confirmed at paragraph 22 that the trial judge's handling of the issue had been entirely correct. Counsel seemed to have accepted the portion of the judgment that, and by counsel, I believe I'm referring to Mr. Warner, that emphasizes that if a defendant fails to acquit himself of an opportunity to do otherwise, the defense is ineffective. Thus, no doubt his emphasis on the threat posed to a family member, but that defense flies in the face of the statute.
Sorry, I didn't understand that. Counsel seemed to have accepted the portion of the judgment that emphasizes that if a defendant fails to acquit himself of an opportunity to do otherwise, what does that mean?
I.e., turn himself over to the police or surrender or escape or
Time when the duress is no longer extant.
yes, that's what that's related to
Yes,
the
I see.
point that I was making.
In respect of a threat to himself.
Yes.
But I mean, the case, yes. Hmm.
So under paragraph 9, therefore, the appellant has made no appeal against conviction. The thrust of his appeal is principally threefold, and it's merely an appeal against sentence. Firstly, that the fact that the appellant had a trial should not have been used against him in the way it was to lose any credit that he would have had he pleaded guilty. And to that extent, I would also
But, Ms. Christopher, I have a bit of a problem with that.
yes,
I mean, the truth of it is that if you follow a course on the basis of negligent advice from your attorney, it may no doubt entitle you to take proceedings in negligence against that attorney. But it surely doesn't entitle you to reopen the criminal process.
okay. I'm not aware of what the legal remedy would be as against the attorney.
Well, you say you sue him. You say you didn't advise me properly. If you had, I would have pleaded guilty. The consequence of that is that I've served however many years in prison. I've been deprived of my liberty for such and such a period, and I ought to be compensated for that.
I personally would think that that's a surprising result, because I think it's the business of the court and our system of justice to ensure that people don't serve any more time than they ought to serve, rather than relying on civil remedies to compensate them.
It's a fact that he pleaded not guilty.
It is a fact that he pleaded not guilty, but
And
he
in
thought
consequence, there was a trial.
that's correct. But the court,
Therefore, he's not entitled to the discount that he would otherwise have received for a guilty plea.
I think the court has some discretion as to whether or not it would give a discount for a plea of guilty, in the same way that it's not automatic. It's not automatic.
You can't blame the trial judge for proceeding to sentence on the basis he did, because there was in fact a trial on the basis that the charges were contested. In effect, it seems to me that what you're doing is asking us to allow you to adduce fresh evidence and to proceed to sentence on a different basis than that was presented to the trial judge.
Correct. Yes, I am inviting the court to do just that. And I think it's apparent that if the court accepts what I'm saying about the basis on which he came to have a trial and what the status of the law is, I believe that the court ought to. And I think that there is an opening, because I don't believe that the learned trial judge, for example, made clear what is the basic sentence, so the court is going to have to re-examine.
I think you're moving on to another point, but with respect, Ms. Christopher, you haven't answered Mr. Justice Smelly's question. Do you agree that you can't blame the trial judge? You can't say that the trial judge was wrong in the basis upon which he was sentencing, given the facts before him, namely that there had been a trial because the appellant, Mr. Davy, had pleaded not guilty.
If the sole question is whether or not, on the basis that he did not give him the credit one gets, of course, for pleading not guilty, then yes. But if that was the sole basis, you can't blame the judge. But I don't think this isn't a question of blaming the judge either. And I think that in the context of this case, the court is going to have to examine the sentencing process in any event. You know, if you narrow it down to that question, you can't blame the trial judge. Of course, you can't blame the trial judge for the fact that there was a trial in front of him with the person pleading not guilty, and then he came to sentence him. But, you know, perhaps if he had granted an adjournment and Mr. Warner had been a bit more reflexive, then...
Oh, that's a different question.
Yeah.
Different but related. We've had 3 solid days, which ought to have been enough for him to understand what the law was before he embarked upon the trial.
That's if you accept that he had understood the law. Like in this case, the direction that the defense was put was so solidly enveloping provisions that did not apply. I don't think that it advances matters to say that he had time to understand, when clearly it seems that he didn't. And like I keep saying, I don't think...
You're conflating 2 things.
Apologize for that.
1, the shortage of time, and 2, the incorrect advice. There was surely sufficient time for the correct advice to have been given. You're saying that Mr. Warner got it wrong. Well, if he did, it doesn't follow that it was because he had 3 solid days within which to prepare.
As trial counsel, I would only say that that having a trial on your immediate horizon, and all that that entails is consuming enough that
I see your client is trying to get your attention.
yes, and with the license of the court, I wouldn't mind an opportunity to speak with him again.
Right.
If Mr. Coelho can assist.
Ms. Christopher, you can, in the lower right-hand corner, there should be an option for you to go into your breakout room.
Okay, so I can just hit it and okay.
Yeah.
Thank you with your license.
And D.O. Balbuda, if you can do the same for the appellant. I don't know how long they propose to be. What time were you considering the mid-morning break?
Well, not. I wasn't considering it for about another 5 minutes.
All right.
We've only had just over an hour. Right. Yes.
Yes, my lord. So Mr. Davy makes the point that Mr. Warner throughout the trial was complaining about the lack of time that he had had. And I believe at least one of the observations were that Westgate is at one end of the island and he's at the other. And even the first day, I believe, was consumed with this adjournment matter and then jury selection. So the relatively little time, we say, for the preparation to be undertaken.
Yes.
Let alone what it's like to be in a trial, getting ready for a trial. So that's what we would have to say about whether or not, the 3 days was adequate time. Mr. Warner didn't seem to think it was, and had sought more and had complained during. And much of the 11th was taken up with matters related to the trial in court.
Did Mr. Warner complain about the lack of time once the trial started on the 15th? Sorry, 14th, is it?
My client believes that he did, but I note that the record is composed primarily of the actual cross-examination and the,
Right. I mean, the record goes to Friday the 15th, and there's nothing in terms of what happened on the 14th, which is actually when the trial started. Is that right?
yeah, and yeah, because much of the evidence, from what I understand, was read in.
Right. Well, there's no, there are no references that we have to Mr. Warner continuing to claim or complain that he hadn't had sufficient time to prepare.
Right, but Mr. Davy is indicating that he did. And again, during the next break, I can try to see whether I could find something in the tabs, because the tabs are also part of the record.
Yes.
If the clerk chose to note it.
Can you just help me on this? Mr. Richardson was sacked because he gave some advice. We're not entitled to know what that advice was, but common sense tells one it's unlikely to have been you're going to succeed, and more likely that it was you're going to fail. I mean, how can we be satisfied that if Mr. Daly had been told by Mr. Warner that he hadn't got a defense, he would have given up?
How can you be satisfied that he wouldn't have?
Well, how can we be satisfied either way?
The only thing I could suggest is the counterpoint. Using Mr. Richardson as a counterpoint doesn't really take us far if there was no relationship of trust, they hadn't seen him or the like, and he had just said it. But if somebody had actually looked at it and said it, we submit the position would have been different.
Yes, I see.
And we offered Mr. Warner a chance to say if he said anything different, but I can't force Mr. Warner to come and give evidence.
Right.
And yeah, we can't force Mr. Warner to come and give evidence.
Anyway, you say the effect of all that is that he should be given the plea, a discount for the plea of guilty. Sorry, he should be given a discount for the plea of guilty that he would have entered if he had been properly advised.
Yes.
Yeah. Right.
But that isn't the sole basis of our appeal against sentence.
No.
I do have issue with the way in which the judge sentenced, which is kind of related to all of that, because we submit, if you look at paragraph 9 of our written submissions, that in giving Mr. Davy a fairly harsh sentence, effectively the judge was basically saying he had an awesome defense that was rejected, and therefore I can't give him any benefit. Whereas he had presented on his behalf something that was no defense, which effectively the jury had no choice but to reject. And insofar as the judge is saying that they rejected a great defense, he is not we would submit exercising the appropriate discretion.
Sorry, could you repeat that? I don't follow where the exercise of discretion comes in.
Well, it is certainly a discretionary matter as to whether or not the court gives some discount for a plea of guilty.
But
And-
you've already said the judge can't be blamed for sentencing on the basis that there wasn't a plea of guilty.
Correct, but going above and beyond that, it's clear that he was sentencing, it seems to me, on the face of it, that he had been given a great defense, which the jury wholly rejected. So therefore, they're calling him a liar.
You said extraordinary defense,
Yeah.
which is an entirely appropriate way of describing it.
Valiantly and gallantly and magnificent. Right.
What
But
you
the fact-
say,
the key-
as I understand it, is he was in fact under duress because there was a threat against him and there was a threat against his family. But the law was such that that didn't form a defense because of the provisions of Section 47 and Section 48. Accordingly, when the jury convicted him, all that they can be taken to have done is to have followed faithfully the judge's direction and to have held that Section 47 and 48 did not avail Mr. Davy. But that does not necessarily mean that they thought he hadn't been, in some sense, under duress, because it may simply mean that they were satisfied that the duress wasn't such as to amount to a defense because of the provisions of the two sections.
That is what half of what I've been trying to say, but so far much more eloquently put.
Well, yes, possibly. But then we have the problem that the judge, on that footing, if that be right, I'm not saying whether it is or isn't, the judge would have to make up his mind whether there was in fact any sort of duress, whether it amounted to an offence or not. And it looks as if he was plainly satisfied that there wasn't.
Well, it looks to me as though he took the verdict as a verdict on the substance of the defense, as opposed to the defense not being made out according to statute. And that, in a nutshell, is the crux of the problem that I have with the way in which the judge dealt with it. And I think the court,
In law, wasn't he obliged to approach it in that way? The jury were the arbiters of fact, and they must have rejected any legal defense he may have had in duress. On what different basis could the judge have then thought, as a matter of fact, that there might have been duress?
because the jury was not, resubmit, in a position to make a finding.
Yes, but then it would require the judge to make his own finding, as a matter of fact. That's not how the process works. That's not how the trial process works.
And Ms. Christopher, isn't it also possible that it's the case that the jury rejected Mr. Davy's evidence that he had been badly beaten, which included beatings of strangling and beating about the legs, so that he said at one point he was so weak he couldn't stand up. And the fact of it is that he didn't have any marks to show that he'd had any beating, and he was able to outrun 3 customs officers when he left the airport.
Well, we say that that because that wasn't an extant threat, that i.e. that beating didn't really function to provide him with the defense for the
He
offense.
didn't provide him with a defense. We recognize that, but it's still a matter that the jury might have simply disbelieved the evidence that he gave.
But that's speculative. And what we have is we have an instance where we know that no defense was provided to the defendant, and that if the jury did as they were supposed to do and obeyed the law as set out to them by the learned trial judge, then
they would convict.
yes. And so
Well,
after
you can't
that,
tell whether the jury believed or disbelieved
we cannot.
the factual averments. The judge has got to make up his own mind, hasn't he?
Right. But to my mind, when you're looking at paragraph 9, it just looked to me like the learned trial judge followed the lead of the jury by saying the jury rejected it all. So that's the problem.
My difficulty with the proposition is that it seems to me that the trial judge was obliged to proceed on the basis that the jury rejected the defense. How else can you approach sentence?
It's my submission that had it be that in order to avoid his ruling on sentence being impeachable, the appropriate course would have been to identify what I put my phone on the other side of the house and it still is me. Okay, shut it off. Sorry. It seems to me in order to prevent his sentencing from being impeachable, he should have indicated that, he should have made it clear that, there was no defense that had been put forward, but that he was making his own finding of fact, as opposed to basically following the tract of the jury and making the guilty verdict.
I understand, but as a proposition of law, that troubles me. The idea that the judge could be required to sentence on a basis of fact that the jury may or may not have considered is not a proposition that I can think of any support for.
Well, if the learned trial judge makes it clear the basis on which he is sentencing, which isn't,
which is that the jury rejected the defense.
Right. Well, if he rejected it all, is what he said, and he sort of abdicated on the basis that the jury rejected it all. He abdicated responsibility for looking at what benefits, if anything, he's going to give this defendant.
But he can't go behind the decision of the jury, though. I don't quite understand what you're saying there.
It cannot be said, we say, that this would be the standard case where a jury has made a finding of fact, or even in some instances, the court cannot assume all the facts that the jury found in favor of or against the defendant, and the court has to take an overall view of the evidence and decide the basis on which to sentence. But in this case, he has abdicated that. I accept the principle that Mr. Justice Smelly referred to, that a judge surely, after a trial, because you're not in the jury room, can make a decision about how to sentence based, having sat through the trial, how to sentence a defendant. But in this case, the judge abdicated that because he was saying that, the jury rejected the defense when really the jury had no choice but to come to the conclusion that they did. And that, and he doesn't see how he can go behind it.
Well, if we might test your proposition for a moment, how then would the judge approach sentence? If he had accepted the probability, shall we say, that your client had in fact suffered some kind of duress or threat, how do you then have approached sentence?
He would have used it as a mitigation.
In what way?
He ought to have used it as a mitigation. And that's where I put forward the case of Downey that confirms that duress can, even if it doesn't amount to a legal defense, constitute mitigation.
Darby, you say?
I believe it's, have a look. Yes, Downer, pages 8 to 12 of the bundle,
Downer.
of the authorities bundle. In that case, the appropriate facts start at page 2 of page 9 of the authorities bundle, paragraph 4. On 15th November 2013, the appellant arrived at Gatwick Airport on a flight from Montego Bay in Jamaica, traveling alone. When questioned by customs officers, he confirmed he was the owner of baggage he had with him, a duty-free bag found to contain a tin labeled ackee and another tin labeled spinach. They were x-rayed and it became apparent that something was concealed, and they found tape wrap packages inside of them, which ended up being, let's see, what was that? Cocaine. And he had several previous convictions for drug offenses. If you look at paragraph 8, he had 15 previous convictions for 39 offenses, which included importing cannabis, importation of cocaine, for which he had previously received 8 years imprisonment. When passing sentence at paragraph 9, the judge said that the appellant felt to be sentenced for the importation of a sizable quantity of a Class A drug. He knew what he was doing. His role was significant. He had previous convictions for importing drugs into this country. The judge referred to the previous convictions, which we have mentioned. The judge alluded that the appellant had been shot, acknowledged that he had been shot and that he had been approached by people after his release from the last sentence of custody he had served. The judge was unable to disagree with the suggestion that there had been, in this case, a degree of duress, but he observed the appellant could plainly have avoided committing this offense had he wished to do so. And
There's
then,
a guilty plea in this case, was there?
pardon?
There was a guilty plea in this case.
Yes, there was a guilty plea.
There is no suggestion of a jury having rejected the defense.
They didn't reject on the facts, they rejected it on the law. So we submit that.
I'm talking about in Downey.
Yeah, at Downey it was just a simple guilty plea. In the case at Barr, it was a rejection of the law, we submit, and not really a rejection of the facts that can be taken from the.
I was interrupting to say we can't say that. We simply don't know what view the jury took of the facts.
Correct.
You say that all would have been fine if the judge had said the jury have convicted the defendant. In the light of my summing up on the law, that may mean they were simply that they were not satisfied there'd been no duress at all, but were satisfied that it wasn't such duress as gave rise to a defense.
Correct.
I therefore have to take it upon myself to determine whether there was any form of duress at all. And in the light of all the evidence that I've heard, I'm quite satisfied there wasn't. You
Correct.
say that would,
He could
that
have
would be
done that.
fine.
That would be fine, but we don't have that. In fact, we have to the contrary, which is why we say that the entire sentencing exercise is wide open.
Right.
So therefore, if you go to the middle of paragraph 10 of my written submissions, which is at the top of page 4 of the submission bundles, we say, therefore, the jury's decision to convict the appellant is not attributable to a wholesale rejection of the facts as the appellant asserted them when it comes to the question of duress, albeit to duress
I don't
falling
understand
short
how
of
you
it.
can say that when we've agreed that we don't know whether the what view the jury took of the facts.
Yeah, I should have included the word necessarily
Right.
attributable.
That paragraph 10 of your submissions.
Yes, my lord.
Right.
So I submit, and it's only a submission, that they were not necessarily rendering a verdict on whether there was duress per se. And I mean small d duress as opposed to statutory duress. Arguably, they were rendering a verdict to say that there was no defense. So this is where we feel that in sentencing, the learned trial judge was in error. Accordingly, we submit that this court can consider what weight, if any, to attach to duress as a mitigating factor. And we say that the case I just referred to confirms that duress can be a mitigating factor. Of course, it being an English authority, I'm not relying on it getting all up into what the appropriate sentence should be.
Yeah.
But
I may be repeating myself here, but wouldn't that necessarily require us to determine as a matter of fact whether there was duress with a small d?
Correct.
How can we do that?
As best you can on the evidence that was presented. I mean,
But what do we know the truth is in that respect? How do we determine whether or not what your client has to say in relation to small d duress was true?
it's not on Mr. Davy. All I can say is you have the transcript and you have Mr. Davy's assertion.
Yes, but I don't see that we could become any more the arbiters of fact than the trial judge himself could have been.
Well, yeah, but if the judge
in
felt,
relation to that question of small d duress, as you put it.
we submit the trial judge abdicated that.
But why should he have assumed that responsibility?
Exactly.
Because, sorry, Mr. Justice Bell.
I was just agreeing with Justice Smelly. Can you use the word abdication when it's not a task he can properly undertake?
It's my understanding that it's entirely a task that a judge can undertake, wherein a judge gives certain directions. A judge is not in the jury room with the jury. The jury rendered a verdict.
Classic directions are that the matters of fact for the jury. And you rely on Downer, but that doesn't take you home, I don't think, because in Downer there's a guilty plea, an entirely different proposition.
Well,
Okay.
could I just add that in Downer it was a question of fact that Downer had been shot.
Yes.
Whereas in the case before us, all we know that despite this severe beating that caused him to be so weak in the legs he couldn't stand up, he was able to outpace the customs officers when he landed in Bermuda, and he didn't have a mark on him.
But I think it's quite customary for people to be assaulted in a way that is deliberately used so that they don't have a mark on them, and to suggest that being beaten hours earlier, such that hours earlier he could not stand and yet he was able to run faster than a customs officer who may have chased them. I think that was a colorful way of putting it all, but I don't think that advances matters greatly in terms of that inquiry. But yes, there is a difficulty that has been caused, but we submit that is not insurmountable because we have the transcript of what was said. Nobody's in an ideal situation when you're not actually in the jury room. In terms of supplanting your opinion, but the fact is that judges are frequently called upon to infer what the jury may have felt or what basis on which the jury were doing it, or even substituting their own view of the facts, which is what he ought to have done in this instance. I mean, I don't think it's correct to say that we don't, that I think with the greatest degree of respect, Mr. Justice Smelly, on the one hand, you're saying, that is, the judge can put his own spin on the facts. And on the other, you're saying, how can a judge come after the fact and say what the facts are? I just think that
I'm not saying that at all. I'm not saying the judge can put his spin on the facts. You are the one who's saying that he has done that.
Well,
what I'm saying is in proceeding to sentence on the basis that the defense has been rejected, I don't think that the judge can be faulted.
The judge can be faulted for saying that the jury have found facts that it is not the case that it can be said that the jury have found.
How do we know?
Based on the fact that effectively there was no defense. There was no defense, which is why they've come back in record time. I mean, if the judge were, like, as I indicated, if the judge were to be making up his own mind on what the facts were and made it pellucid, then I don't think we would be in this position. However, that's not what happened. He automatically took the finding of the jury as a finding of fact.
Well, what are you inviting us to do?
I'm advising the court to address this matter as if it were a defendant who had presented himself on a mitigation, on a plea of guilty, with this question of duress.
So it's two things then. First of all, you are saying that he should be treated as a defendant who didn't have proper advice, who would, if he had had proper advice, have pleaded guilty. And secondly, not only would he then be entitled to the discount, as if he had pleaded guilty, but also that we should accept as a matter of fact that he had acted under duress.
I think you should consider it, but I'm not saying that, I'm not trying to tell the court what decision it ultimately should make, because effectively, you weren't, I actually think that under the circumstances, because of the way it was handled, this court ought to find, that it's possible that there was duress and sentence on that basis. But that's my view. It's a matter for the court. But I don't think it's impossible to reach a fair conclusion.
What you're in effect saying is that the judge ought to have, despite the fact that there was a full trial, the judge ought then to have had, in effectively, a Newton hearing. Do you know what I mean by that?
Oh, I know what a Newton hearing,
Yeah.
hearing is,
Well-
but no, he need not have a Newton hearing once he's actually sat through the evidence.
Right.
If he can
Okay.
make and
Yeah. Okay.
make it clear that, but with the knowledge that it's not the case that
Right.
that the jury verdict is a wholesome.
Right. So the judge should have
Rejection
reached
is
his
fine.
independent decision,
Correct.
having heard all the evidence, as
Correct.
to whether there was duress with the small d.
Correct.
He didn't do so,
Correct.
and therefore we should
Do that.
do what?
Consider whether there was duress with a small d.
Right.
But that is only a small part of my, not a small part, that's only a part of my
Yes, I know.
submissions.
I mean, what could be said is that if in fact you choose to defend the case upon the footing of duress and fail, you can't then have a second bite of the cherry and say, oh, well, of course, it wasn't a defense at all, but it might be a mitigation. So can we start the process again?
Well, we're not trying to start the process again. We're trying to invite the court to start the sentencing again. But if it were a case that duress were running, where there was scope for the running of duress, of course you can't, because that would involve, by necessity, a jury making a finding of fact that the defendant has not, that the prosecution has proved their case, notwithstanding the facts averred to by the defendant, such as,
Okay. Well, what we've got next is the leaving aside questions of guilty plea and duress.
correct.
We've got the level of sentencing anyway. I
Yes.
wonder whether now might be a convenient moment to have a 10-minute break.
Yes, sir.
Right, 10-minute break.
10:50.
Hmm?
10:50.
And what are the instructions, Mr. Coelho? Are we to just leave or turn
You
our
can
cameras off?
Just turn your cameras and mute your mics.
Okay, thank you.
And I can go to the breakout room with my client.
Yeah.
Yeah.
And destroy all telephones in your presence.
Yes.
I'll try to figure out how to turn it off in the meantime. It's not in my presence. It's way over in the laundry room.
Destroy all telephones in your house.
Kind of expensive. But, okay. All right. Thank you.
So do we go to the breakout room?
I assume we do. Justice Smelly, I shall try to.
Yeah.
Mr. Richards? Well, okay, I see you. I
Hello,
don't,
yes, I'm here.
don't see Miss Christopher. Hold on.
Yes.
Okay. So I took from the last time that we were here that you wanted me to move on. So I'm moving on to paragraph 12.
Yep.
Of my submission,
Yes.
which is that, quite apart from anything else, the sentence was manifestly excessive. And I make reference to the case of Loddymore and Hatherley, which is at page 13 of the authorities bundle.
Yes.
Which wasn't actually an appeal against sentence, but it is illustrative of a trend in drug sentencing in Bermuda. So I just wanted to highlight a few passages from this, but I appreciate that it's the Supreme Court matter and doesn't delve into the reasoning with respect to sentencing. In this case, 2 appellants were convicted in 2012 by a jury of conspiracy to import heroin. Hatherley was sentenced to 12 years imprisonment, and Loddymore was sentenced to 15 years of imprisonment. If you look at paragraph 6 on page 14 of the bundle, on 7th October, an air ramp employee called Wade was arrested in Philadelphia International Airport after being found with a hold of the aircraft the previous day without authority. He admitted having put marijuana on a plane bound for Bermuda and later agreed to assist the U.S. authorities in relation to a drug ring importing drugs into Bermuda. Their telephone calls were recorded between him and a man named Afro, and my understanding is that Afro is Loddymore, and Bermuda making arrangements to send drugs from the U.S. to Bermuda. Paragraph 8, Afro called Wade to expect contact with this boy, who was actually Heatherly, who arranged to meet and pass over the drugs. And the amount of drugs is confirmed at paragraph 32, which was 388 grams of cocaine. That was handed over to Heatherly in New York.
388 grams of heroin, wasn't it?
Yes, sir.
Sorry, I thought you said cocaine.
Apologize, sir.
Right.
So those are the facts in respect of which they received sentences of 12 and 15 years. And clearly, Mr. Loddymore was at the center of that conspiracy. He was not a courier, as is being suggested in this case. And I also allude to the case of Richards, which, despite its vintage, keeps coming up in consideration of these cases, for at least the first. That's at page 22 of my bundle. Richards pleaded guilty to 1 count of conspiracy to supply cocaine, which had been imported via a cruise ship. When sentencing Richards, the judge commented that on the agreed facts, Richards played a supervisory role. He rejected the submission that his part was a less serious one than that of an importer, And he observed conspiracy is invariably covert and encourages ongoing criminal activity. It is not in dispute that Richards recruited drug couriers, that he got in touch with the Bermuda receiver, that he sent the drugs here, arranged for the courier to collect money, that he kept some and that he sent the rest to the New York supplier. He therefore took an active and essential part in the import of drugs. Because he was an organizer and supervisor, he should, as a general rule, be more severely punished than an importer who merely carries the drugs ashore. So,
Just two matters in relation to this.
Yes, sir.
This was a sentence on a plea of 12 years, which would appear to indicate that if there hadn't been a plea, the sentence would have been 18 years.
Yeah.
Is that right?
Correct. For a supervisor.
Yes. And nowadays it would be 18 plus 9, which would be 27. And the quantity was half the quantity in the present case.
Well, if you look a bit further down, where I think they're looking a bit more closely at the couriers, it says, if you look, I don't know, about 10 lines from the bottom, a bracket of 8 to 12 years would be the appropriate starting point. So,
Yeah.
and you know, there were a lot of different points. I mean, this was a very important case in Bermuda's jurisprudence, and certainly in respect of the issue of the supervisors, that principle still remains important. But it also involved, you know, importing via a cruise ship and the impact it has on the tourist industry to have to monitor all the tourists for imports on board a cruise ship, because they used to get a sentence that was increased because they were on a cruise ship and the like. But the key point fact I'm pointing to is the supervisor role, and going back to.
And that might have brought the 27, which the president referred to, down to something closer to the 18 in this case.
It would have, but that would have been with the markup because it was a cruise ship case, which was another markup.
Was that a statutory markup?
No, it was judge imposed. It was,
Right.
yeah. I mean, it's might as well have been because anybody who imported on a cruise ship got an additional sentence.
Why should we assume, in the light of the jury's verdict, that Mr. Daly was simply a courier?
There's nothing to suggest that he wasn't a courier.
Well, wait a moment. If the account that he was forced to take these drugs because of threats upon him or his wife and child, if those were untrue, the fact of the matter is that he imported $750,000 worth of cocaine with no indication that he wasn't doing it other than for himself.
We don't have a jury finding that, as I say, we don't have a jury finding that he wasn't a courier. We're not able to dissemble if any facts were, in point of fact, considered by the jury beyond the direction that they received on the law. And with there's nothing to suggest he wasn't a courier. It's
right.
I'm not aware of many, if any, cases where somebody who's not a mere courier is bringing drugs into Bermuda.
Right.
So
Okay.
And with these sort of sentences, who would?
Right.
I mean, if they knew really enough about it. So is my submission he should be sentenced as a courier. And I don't believe that the Crown, as part of their case, asserted otherwise than that he was a courier.
Right.
But Ms. Christopher, in relation to anyone who imports serious drugs, and we are, I think, talking heroin here, shouldn't we have regard to the case of Cox and what Justice of Appeal Mantell said, that it was well recognized that in cases of commercial importation of crack cocaine, the starting point following a trial was unlikely to be less than 12 years. That's 56 of the record in the judgment of the former president on Tyrone Brown. So that's the starting point before the uplift, isn't it?
It is, well, the starting point should consider whether or not, before declaring it the starting point, whether or not there's any mitigation. And it's only once you've established the sounding point, which, like I said, subject to mitigation, that you then consider any uplift.
Correct, understood.
So in this case, for example, we would be saying that if the court considers that there was some duress, that would effectively help to lower the starting point.
Yeah.
And therefore, of course, proportionally, the uplift would be lowered.
Yep. Yes.
Again, if you look at paragraph 13, and this sentence was considered by the Court of Appeal, the case of Morris and Morris, which is at page 27 of the bundles of authorities.
Yes.
In that case, Mr. Morris and his mother were convicted after trial on a number of drug offenses. He was charged with conspiracy to import diamorphine, possession with intent to supply of a controlled drug, cocaine, drug equipment, and his mother was being done for a money laundering offense. The actual discussion of sentencing starts at paragraph 26, which is on page 31. Paragraph 27 says the case against him was that he was arranged for Michael Tucker to fly to England and import drugs into Bermuda. The importation was part of a joint operation between persons in the UK and Bermuda involving some planning and sophistication. Tucker was caught on his return at the airport with 86 grams of heroin worth $253,000. His premises were searched and 2 separate hidden quantities of cocaine were found of a lesser amount, and a pair of scales as well was found. He was of no previous convictions, age 28. Importing heroin is a particularly serious crime, carefully planned offense, of which he was at the heart. He was responsible for involving Tucker, an aggravating feature of an already serious offense. Counts 2 and 3 indicate that the conspiracy in count 1 was no isolated involvement in the drug dealing world. Then it went down at paragraph, it deals with Tucker and Simons, but I have Tucker and Simons separately here, and the court seemed to accept. It also deals with Brown at paragraph 32. We recently affirmed, let me start with Tucker. In Tucker and Simons, President Zaka explained the procedure to be followed when sentencing in cases to which Section 27B applied. He said this: the proper procedure would be for the court to fix the basic sentence. We understand that this to mean the appropriate sentence for the offense charged after considering all the circumstances of the case, including any discounts. Having fixed that sentence, the section provides that 50% of that figure should be added to the basic sentence. We recently affirmed that in Brown. The judge in the present case did not initially follow the appropriate procedure, but when it was drawn to her attention by Mr. Musselin, she said, perhaps I should have said basic sentence of 8 years for the conspiracy, with the uplift would have amounted to 10 years. She referred to a similar adjustment with counts 3 and 4, again reaching the original result, which was 10 years in that instance. And after further argument, made a further adjustment to 10 and a half, commenting that the totality was relevant to the final figure. This approach was rejected because I think it seemed like she adjusted her reasoning to fit the ultimate conclusion. In the Crown and Rahman, leave to appeal against 17 was refused. That case involved conspiracy to import heroin, although the report describes that neither the amount nor the street value, but the DPP says in his submission that they were a little less than in the present case. The sentencing judge held that the basic range was 8 to 12, with which a 50% uplift took it to 15 years imprisonment. The additional 2 years is irrelevant to the circumstances of the present case. Deals with Richards, which talks about considering a longer period, a person who are organizer or supervisor,
And it said on the next page that that was pre the uplift.
Yes, that was prior to the uplift. It was 1991, I think Richards was. That's why I'm only relying on it says that they are limited assistance. And I also observed that that's why I was just the supervisor role. I'm really concerned about eliciting out of that, which I think has survived the uplift in other trends. And in sentencing him to what was ultimately 18 years, it was said that the serious features of the present case were that Damon Morris was an organizer in a conspiracy to import a substantial amount of drugs, that he suborned Tucker, and that there was evidence of a considerable amount of cocaine for dealing at his home. In our judgment, the 12-year sentence was manifestly excessive and did not reflect the statutory uplift required. Accordingly,
The total sentence of 12 years was manifestly inadequate.
Correct. And and that was raised for the supervisor to 18 years.
Yeah.
But we're not talking here about somebody who can be shown to be a supervisor. And certainly when they were saying that Mr. Morris was a supervisor, they were using scales and other evidence of drug dealing. I think there were like bits and pieces of paper and all sorts that the Crown were using to support their case that Mr. Morris was a regular drug dealer closer to the top than the bottom of the chain, and possibly at the top of the local end of the chain. So it's my submission that I don't understand how Mr. Davy ends up in the same position as Mr. Morris. Safe to say, I do notice a disturbing trend that if you're Bermudian, you get a different sentence than if you're not Bermudian. It just seems to me, all things being equal. So in this case, this person who cannot be, it's not suggested that he's otherwise than a courier, gets the same sentence as a gentleman who is, it seems on the face of it, at the top of the local chain for a drug supply of heroin, and seems to be regularly engaged in that, which I don't believe the Crown to be suggesting in the current case.
In Morris, the drug was cocaine, though, not heroin.
Right, but they both get the uplift.
Yeah.
Cocaine gets the 50% uplift as well. So the statute, I think the court has determined that they are to be treated the same.
What, heroin and cocaine are to be treated the same?
Correct. They both receive the statutory 50% uplift.
Yes, they both receive the uplift. But I've seen somewhere Justice Graves saying that heroin was at the top of the list of seriousness before fentanyl came along.
I believe that, but I don't think that that sort of accounts for a different starting point. In point of fact, what used to happen was that heroin and crack used to both
Be treated, yeah.
a similar punishment, but then the courts ultimately did away with the distinction between cocaine and crack because it's a very simple process to convert cocaine to crack. I think that's in the Swan case that my learned friend had added to the bundles. So it's my submission that that it really would be apropos to compare the two. But in any event, Morris, I think, imported heroin and had cocaine. So all things considered, it's sort of, I don't see how you could differentiate this ringleader.
If you look at paragraph 27 on page 31, he arranged for Tucker to fly
Correct.
to England and import drugs.
Correct.
Part of a joint operation involved some planning and sophistication. Tucker was caught on his return at the airport with 86 grams of heroin with a street value of $253,000, and then a much smaller amount of cocaine, 19 grams, with a pretty modest street value, was also found. So far as the heroin was concerned, he procured the importation of 86 grams with a street value of $250,000 approximately. Whereas in the present case, what's been imported has been 220 grams worth $750,000.
Do you really want to differentiate between somebody who suborns somebody to bring in 86 grams of heroin and is found with cocaine, and then a courier who brings in, and by the way, who isn't either much in control of either its purity or exactly to a.
I think the point my lord is making is that in the present case, the quantity of drugs and its value was approximately 3 times that of this case.
Right, but it's not a simple numerical exercise, and I don't think that a courier not really being really not, I wouldn't say responsible, but a courier, it's not like a courier says, give me 100 grams of heroin or give me 150 grams of heroin or anything like that, such that when we come to somebody who's at the top of a conspiracy, receiving a sentence of the same as my client is getting, I don't really think it compares. Whether it's when you're talking about couriers, the amount doesn't really matter much. I don't think.
Right.
I mean, and of course, Mr. Luttymore had, for what it's worth, 388 grams of heroin.
Yes.
The case of Tucker, I've already alluded to. I don't think we need to go to it specifically. That actually case, I argued it because prior to that, the case of Rahman wasn't applying the discount on the basic sentence. But this Tucker and Simons does establish the basic principle that is applied to the basic sentence. But otherwise, it's quite a different case. So in the case of Barr, it doesn't seem that the judge gave any consideration to what the starting point should be. I don't believe that he actually stated a starting point.
Is this Alomar?
Yeah, I also got on to Alamar, which she received a sentence of 8 years imprisonment for 146.3 grams of heroin at 16% purity. And the judge considered that she was a vulnerable woman with a family. I believe that one of her children had a disability. That case is at page 39 of the authorities bundle. The respondent, if you look at paragraph, the second paragraph, on arrival in Bermuda, was stopped, searched, and x-rayed. 15 capsules were recovered, 11 from her vagina and 4 from her rectum. The contents were 148.3 grams of a light brown substance containing 16% of the controlled drug diamorphine, i.e. heroin, with a street value of 158,180. She cooperated once found. She was an American, 42 years of age, describes her children, one of whom had mental illness, received psychiatric care, but was at home sheltered by the respondent. She held on a job, but was in financial difficulty, and that led to her accepting an invitation to courier drugs. And then she had received 4.5 below. And then if you look at the penultimate paragraph, as we have said, although they do not count for much, there are other grounds mentioned that do attract discounts, although in the particular circumstances here are very modest discounts. There are also the compassionate grounds mentioned by the judge and indeed by this court during argument. Having regard to all of that, we do not make it possible, taking the most sympathetic view we can, to reducing the sentence below 8 years. But this, I think, was before we had the statutory uplift.
Well, let's just look at this case a little more carefully.
Yes, my lord.
The lady was a courier, was she?
Correct.
So she was a courier. She imported 148 grams.
Yes, my lord.
Whereas in the present case it was 220.
Mm-hmm.
And it was also
Sorry?
also 16% purity compared with, I think, 44.
Right. And worth 158,000 instead of 250,000.
Three-quarters.
And the sentence was increased to 8, which is consistent with a sentence before plea of 12. If 12 was right in this case, it can't have been manifestly excessive. I'm sorry, if 12 was right in Alomar, the sentence in this case can't have been manifestly excessive because they were both, the 18 in the present case is effectively 12 plus 6.
Yes.
And if you look simply at the 12, the facts in the present case are markedly worse than those in Alomar.
I would say that the method of concealment, for example, which is one of those instant ways in which you differentiate worse couriers by concealing it in bodily orifices, that's sort of an aggravating factor. So on that basis, the facts aren't considerably worse.
You've got a significantly lower quantity of drugs in terms of both weight and street value. And in the exercise just undertaken by my lord, it comes to an equivalent of 18 years, the same as in the Davies case.
Well, I would say that this was heroin. So,
So, Davies.
pardon? Yes,
So-
I agree, but I don't think it's fair to compare a sentence for heroin at 12, which was already it being heroin, at that stage attracting a 50% increase on what it would otherwise have been, and then adding another 50% on top of that. That's sort of like compounding. So
there were two exercises. One was the guilty plea exercise, which took the 8 years up to 12, and then there was the uplift factor, which took the 12 to 18.
right, but in 2003, following the case of, I believe it might have been Richards, it being heroin, she would have received a sentence that is taken to have included her 50% uplift for it being heroin. In any event, already before they arrived
Following
at
that, the 50% uplift came with the amendment to the Misuse of Drugs Act, which came into effect on the 4th of August 2005.
But prior to that, there was a judge-made provision, I believe, like I said, that it was out of arising in Richards, whereby you got 50% more if it was heroin. So that sort of reasoning had already been applied to heroin cases in 2003. So you can't say, well, 12 was the starting point. She got 8 because she got a third discount after her. I don't, you can say that it was 12 was the basic. It was kind of like 12 would have been the basic sentence, I guess, to get back to 8 for the plea of guilty. But people were still subject to a 50% basically tax on your sentence by virtue of Richards.
Miss Christopher, aren't we overlooking the fact that Miss Alamar pled guilty?
No, we're not overlooking the fact that Ms. Alamar pled guilty. I'm simply making the suggestion was being made that that this was pre the statutory uplift in 2005 or whichever year it was. So therefore, it was basically 1/3 off of 12, the basic, like what we theoretically look at as the basic sentence. And I'm simply saying that when she was sentenced, people who were being sentenced for the importation of heroin were already attracting 50% because of the nature of the drug.
I don't follow you. Insofar as the Court of Appeal changed the sentence to 8 years on a guilty plea, you agree that that would equate to 12 years after a trial, and that the Alamar case was before the 50% uplift was.
Before the 12%, before the 50% statutory uplift, but not before the 50% uplift for importing heroin or crack cocaine.
Well,
so I'm simply saying that you can't take the case of Alamar and say that she got what is the normal sentence at the time, treating the 12 as a basic sentence, because she had heroin, which at that time got a 50% uplift.
Doesn't seem to be any reference to a 50% uplift in this case.
Right. If you look at page 26 of the Joint Authorities Bundle,
Yep.
which is the case of Richards,
Yeah.
In that case, they were, if you look at the middle of the page,
Yes.
it said the totality of 9 years cannot be regarded as too severe. The import of heroin into Bermuda is, as the judge observed, a matter of considerable concern. It is a powerful and dangerous substance and should be treated in the same manner as crack. This means that those who deal in heroin can expect a 50% higher sentence than they would do if the substance were cocaine. So when you look at Ms. Alamar's sentence, first of all, this is an instance where the Court of Appeal, it seems, had some compassion for a vulnerable courier, but I'm going to assume that they, in arriving at 8 as their sentence, they factored in the case of Richards, which was the case of every single drug importation case prior to that, prior to Alamar. And I don't see why it wouldn't have included Alamar. I mean, this is the Court of Appeal. And also, taking into account the purity of the drugs, although it's a very attractive argument, it's been it's been raised and dismissed many times. That certainly our Court of Appeal is not as yet in terms of making an assessment of what the sentence should be, taking into account the purity of the drugs. And I've frequently been present when the court, I'm talking like 20 years ago, indicates that it may be time for somebody to run that point. But the court has traditionally not taken into account purity. So that's not a factor. And
Saying we should treat 100% pure heroin in the same way we would treat 16 or 20% purity?
well, that's what the court has said. I mean,
The fact of it is that you've got 100% purity. That means it can be cut by impurities to
correct.
And therefore, when it comes to the number of decks that could be sold on the street, the number is that much greater, and the value is that much greater.
I've made those arguments, but traditionally the Court of Appeal hasn't considered. And if this court is to consider that, then okay, then for future reference, then we will argue purity. But all I can say is hitherto, the Court of Appeal hasn't been concerned to get into the niceties of the purity of the drug.
Well, but the court does look at the value of the drug, and the value of the drug comes from the exercise of working out how many decks would be provided by the quantity of drugs with the purity, and the police officer then applies his $20 a deck figure to the number.
They do not. I mean, you get a low quality of heroin, or you get a higher quality of heroin. I mean, that's not my, well, we haven't hitherto had, as far as I'm aware, and I stand to be mistaken, expert evidence that delves into that question, which is part of the problem with the black market of drugs.
Excuse me.
Hello. 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 I'm saying no more, Miss Christopher, than that it makes obvious sense that if you've got 100% pure heroin, that it can be diluted to make a greater number of decks. And I'm looking at the evidence of the policeman, which is to be found at 399 of the record. That doesn't deal with the change in the purity of the drug, but it just deals with how he gets to his number of $765,000.
Okay, I'm only saying this, and I'm not disagreeing with the reasoning of the court at all, right? But I'm just dealing with how how sentences are meted out in my, I've been doing this for 30 years, how sentences are meted out. I've made purity arguments without all sorts of expert evidence or what have you. And the judges have refused to consider the question of purity. I can't remember if it was Zimbardi, but it was in that era, which would have been in the mid-90s, that we were talking about that issue.
Right. And what you say is that purity simply means that the purchaser of a deck at $20 might get a different
60% or 20% or 46%
or whatever it
or
may be.
80%.
Yeah, I have that point.
Yeah.
We may come to look at the Swan case, but I remember that section 1(4) of the Act was considered, where it directs that the street value of a controlled drug shall be value for which evidence is accepted by the court as the maximum value the controlled drug can be sold for in Bermuda. And that then led to the question of whether crack cocaine or powder cocaine fetched a higher value. I think Justice Bell's concern is whether heroin of a higher purity would not be able to fetch a much higher value than heroin of a low purity.
Right. And the answer to that is that has not been established. That's a different question from reducing crack cocaine to crack cocaine, which is from what I recollect of the Swan case, it seemed to be suggesting that that's a very easy process, because I think that in that instance, it involves a similar process to that, which
Well, this was a particular sort of cocaine and
well, it was suspended. It was in
soaked in paper, and it was then a question of whether or not and how, with the addition of chemicals, it was converted into crack cocaine.
Yeah, which is an easy process.
So the way I put the question is whether or not the purity of the drug would not be a factor to be considered for the purpose of section 1(4) of the Act.
Right. And
that is the way I put the question.
Right. And I say no, and I say it hasn't been shown that that amount value of drugs would attract a lower sentence. A lower street value, because you take what you get on the street.
I see. You said there's no evidence, at least in this case, that the higher purity would have resulted in a higher value.
Correct.
I see.
You take what you get. The question of quantity is a different issue, but the question of purity is yet to be resolved. And I say 20 years after I said it before, really almost 30, 25, that perhaps it's a matter that should be tackled in the same way in which perhaps in the right case, the question of couriers ought to be tackled.
But we can't tackle it in this case because
it's too. I actually considered it, but I figured there are too many factors to make it a straightforward method to get a clear answer. Right. So I simply rely on Omar. I think I was pointed to it because I just included it, but to say that it's not impossible that there would be mitigation in this jurisdiction for factors that may make somebody, because she's vulnerable because she needs money, then, how is somebody who is under duress not vulnerable in a way for the purposes of sentencing? So, so I said at paragraph 15, it does not appear that much, if any, consideration was given to what the starting point should be. I don't believe that the judge states what his starting point is, which feeds back to the responsibility being on this court to establish the sentence. And as such, no reasons are cited because there's no starting point cited, so no reasons are cited. Which is why I just keep going back to look at the end result of how we sentence foreign coroners and how we sentence locals who are inevitably more than couriers, and how these disparity of sentences are arising.
The judge has gone straight to the 18 to 21, as opposed to saying the starting point is 12 and there's the 50% uplift. But given the fact that the judge is very experienced, he must have had those numbers in mind, mustn't he?
Absolutely not. I mean, why wouldn't he have done that? That seems basic, but furthermore, he still hasn't shown, well, he's obviously not applying any mitigating factors to the basic sentence.
Right. All I'm saying is that the judge is well aware of the provisions which give the uplift. He hasn't applied, or hasn't said he's applied the uplift in this case, which must mean that he started from 12 and went to 18 with the uplift.
Well, the problem with in sentencing is where you don't state reasons, that opens a subsequent court up to making an examination for themselves about what the appropriate sentence should be.
Right.
So
I
don't think what he must have done advances it much, because his ruling is supposed to be transparent.
Right.
What do you?
Paragraph 16 we've dealt with. Pardon me, sir?
At page 388 of the record, between lines 3 and 10.
He does do that exercise.
Yeah.
So sorry, which page were we looking at?
388 of the record.
Yes. Yeah.
Which also refers to having taken mitigation into account.
Yeah.
One moment.
Yeah.
It's my submission, though, that I see what the court is referring to, but it's still my submission that that particular paragraph is opaque with respect to whether or not he's taken any possible mitigation into account and what that is. Because I'm trying to figure out what he's saying that would be. Yeah, I don't understand where it would be. Like, I don't understand how it would possibly get to 21, for example. If he's saying it would be 21, but I'm saying it's 18. I don't understand what he's taking into account here. On page 388. I mean, in fact, I don't really understand what he's saying, because he's saying that defense counsel says that there's mitigation. There's something that's a mitigating factor. He says it's not. So he's given him mercy.
Well, it's very confusing. He says this sentence could be greater, i.e. more than 18, but perhaps I'm influenced, i.e. in not making it greater, by the one submission of the defense counsel, which he says is a mitigating factor, and I say is not. So perhaps in reducing it from 21 to 18, I've somehow been influenced by the mitigating factors relied upon by defense counsel, which I don't think are mitigating factors anyway. It's all very tortuous.
I mean, what is he saying? That he thought 21 was the appropriate sentence? Yeah, I mean, what is that saying?
Well,
Like,
I don't know, but forget about 21, because he didn't impose that.
No,
It's quite clear that he took a starting point of 12 and an uplift of 50%, because that's what he says.
Mhm.
And it's tolerably clear, if you go to page 385, that he'd considered the mitigating factors that had been relied on: lack of any known previous convictions, young man of 38, young child, man of God, begs for mercy, and says that in his view, those are not mitigating factors in this case. So effectively, he finds that there weren't any relevant mitigating factors.
and didn't number among them small d duress.
Well, he's, I think, proceeded upon the basis there isn't small d duress.
Well, on the basis that the jury made a finding.
Yeah.
Which I don't think can be extrapolated from the way in which the trial progressed.
Right.
Well, I think
So
one
you
can
say that what he should have done was to give a discount as if there was a plea of guilty. And a further discount for duress. So the appropriate sentence would be 12 years imprisonment, which is 8 plus 50% for making 12.
Correct.
That's your submission.
Correct.
Right. Thank you.
Correct. Yeah. That is effectively my submission.
Yeah.
But I do apologize for paragraph 15. I think that's where it is. Yeah, I do apologize for paragraph 15 of my submissions.
What are you apologizing for?
Putting misleading material in my submissions.
And what's the misleading material?
That he didn't give consideration to what the starting point should have been.
Oh, I see. Yes. Okay.
Right.
Could I just
that it's not clear exactly
Okay.
where all that is enunciated is coming from.
Right.
could I just ask you, Miss Christopher,
Yes, ma'am.
at page 385 of the record, the judge says it's not a difficult sentencing. I could simply adopt all the submissions of the Crown as my own. I see no reason to differ from them or to divert from them in any way. And if you go to page 392, which I think we've looked at before, the Crown was saying, it's submitted that the defendant is wholly to blame for his role in these offences, and that's something with which the judge agrees. Is that right?
You said 392?
Yeah.
Oh, 392. Sorry.
These, as I understand them, are the Crown's sentencing submissions. Paragraph 12 at the bottom.
Yes, but that shouldn't be taken to be viewed that his role was otherwise than a courier. That is part of the pro forma in every single sentencing submission. So it doesn't mean that he has a role above and beyond that of a courier. If the court is taking from that.
I was dealing with the mitigation and the notion that we can take duress into account in mitigation.
Right, but I'm simply saying that that is pro forma. that is the pro forma sentence that, you know, you are here, you are convicted of this, therefore you are wholly to blame. I've never seen a submission that has anything but.
It means what it says, Miss Christopher, and the judge says that he agrees with it. That's the point.
Okay, but
With
I don't.
with emphasis on wholly to blame.
Pardon?
With emphasis on the expression wholly to blame.
Yeah, that's pro forma. That's pro forma. Whether you're a courier, whether you're whatever role you adopt, whatever offense it is, I've never seen that sentence omitted from any submissions. So when it's accepted, that, you know.
So when the judge says that he agrees with those, it does mean, does it not, that he accepts that whether you describe it as pro forma or not, the judge is agreeing with the Crown that the appellant in this case is wholly to blame.
And although you say it's pro forma, it does go on to say that the defendant's evidence was wholly concocted in a desperate and transparent attempt to elude justice. The judge accepting that would suggest he doesn't for a moment accept little d duress.
Well, if if his pro forma ruling accepts their pro forma position,
You can't call it pro forma. The judge has made his comments. He's agreed with what is in the Crown's sentencing submissions.
well, that would be because he's misread the or he's sort of taken an incorrect approach to the jury's verdict still, if that were correct, because he's saying underpinning every comment that he makes is his acceptance of the jury verdict as meaning that they found as a fact that duress as a fact was not found. So my position on that point remains.
Right, we have it.
Very good. Well, that's the most convenient time to take a break.
Mhm.
So I think we'll resume in an hour's time, if that's convenient to everybody.
Okay.
Yes, my lord.
Right.
1 p.m.
Right.
Sorry, just has Miss Christopher actually concluded now, or does she have more to submit when we return?
No, I assume she had concluded.
Yeah, I had, and then I realized I wasn't sure.
Yes, I've concluded.
Yes.
Right.
Okay. Right.
1 p.m., my lord.
Yes.
All right, thank you.
Very good.
And Mr. Coelho, should we leave the meeting or just mute our cameras?
Mute cameras and mics. Or turn
Okay,
cameras
thank you.
on, mics, yeah.
And we'll break out, if we may.
Yes.
So we're going into the breakout room.
Okay.
Is that correct?
Yes. We'll convene shortly, everyone. Justice Bell, could you come over into the judge's room?
Certainly.
Thank you.
I don't see an invitation to the breakout room. Here we are. Got it.
Okay. I don't see Ms. Christopher.
Yes, I do.
You see Ms. Christopher? Ah, there she is.
Ah, good. Are we all present and correct? I think we are. Yes.
I'm present, my lord, but I suppose only you can really say whether I'm correct or not.
Ho ho. Well, let's see what you have to say, whether right or wrong.
Yes, my lord. I wanted to start with the chronology of the proceedings because the court did ask my learned friend some questions about that at the start of her submissions. And it appears to me that these proceedings commenced in July of 2018. Mr. Davy made his first appearance before the Magistrates' Court on the 16th of that month, when he was represented by Miss Mulligan. The case was sent to the Supreme Court. His first appearance in the Supreme Court was on the 4th of September 2018, when Mr. Davy continued to be represented by Miss Mulligan, but on that occasion no plea was taken, as full disclosure had not yet been made. Then on the 10th of October, I'm sorry, the 1st of October, so the next arraignment session, the matter was back before the Supreme Court. Miss Mulligan was still appearing for Mr. Davy, but I have a note that she was not properly instructed, which I take to mean either that she wasn't in receipt of funds or that the legal aid certificate hadn't been regularized at that time. But she did confirm to the court that she had received disclosure. she nevertheless was content for the defendant, it seems, to enter 3 not guilty pleas to the 3 counts in the indictment. And as your lordships will know, not least from the parent chief leader decision last year, the statute provides that that is the cutoff point in terms of a Section 31 application. So counsel must clearly have satisfied herself that such an application was not appropriate at that stage. And then the next appearance was on the 17th of January 2019. That is the first time when Mr. Richardson appeared before the court, and he had some difficulty with the trial date that had been given. But that is the date that Mr. Richardson came on the record. There was then, I believe, a further mention when Mr. Richardson attended on the 22nd of January 2019. And then there was the subsequent appearance that your lordships have already heard about for trial. So the simple point that the prosecution, or the respondent rather, would respectfully make is that Mr. Davy had throughout the early course of these proceedings the assistance of 3 very distinguished defense counsel. I'm delighted that none of them have been extinguished. In my respectful submission, it is simply inconceivable that they had not appreciated and advised him that the defenses that he contemplated running were difficult. Now, there's been some discussion between the court and my learned friend in respect of sections 47 and 48. And as your lordship knows from my written submissions, which I hope you have had the opportunity to at least glance at, I do concede that section 48 was not available to the defendant on the facts that he asserted, in light of the fact that it requires the threatenor to be physically present with the individual threatened. And so I think on reflection, it would perhaps have been appropriate for the Crown to invite the learned trial judge not to give a direction in accordance with section 48. But of course, the fact that one was given did not in any way disadvantage the appellant. And of course, there is before the court no appeal against conviction. Indeed, there couldn't be in all of the circumstances, as my learned friend concedes. But in my respectful submission, the learned president has identified the flaw in my learned friend's submissions with regard to section 47. She is right that a threat to a third party, as was alleged here, cannot serve as a foundation for acquittal pursuant to section 47 unless that third party was present with the defendant at the relevant time. But as my Lord President has clearly identified, section 47 is not confined to threats to third parties. It includes threats to the offender himself. And I understood my learned friend, Miss Christopher, to be suggesting that in those circumstances also, it is necessary in order for the defense to be viable for the threatenor to be present. But there is nothing to that effect in the language of section 47. And one might think that there would be if that was intended, bearing in mind that the presence of the threatenor is spelt out in section 48, whereas it clearly is an express agreement, express ingredient of the section 48 defense. It clearly is not an express ingredient of the section 47 defense. So in my respectful submission, however factually fraught a defense pursuant to section 47 was, and however strong the prosecution's case was to the effect that the accused's defense in this case really was a fantasy, which the respondent respectfully maintains before this court. The defense under Section 47 was legally available to this appellant in this trial. And it would have been quite wrong, in my respectful submission, however weak he might think it was factually, for the learned judge to have withdrawn that defense from the jury's consideration.
Can we just pause there a moment?
Of course.
The words of the statute are where the act or omission is reasonably necessary, and the act or omission here is the importation of the drug,
Yes.
for the purpose of resisting actual violence threatened to him or to another person in his presence. Now, there was no threat made to his wife and child in his presence, because his wife and child were not there.
Correct.
But when one talks about actual violence threatened to another person in his presence, one is envisaging a situation where the defendant is physically present with somebody else, call him X, and in those circumstances, violence is threatened against X. Go back to the first half of 47. Forget about threats on third parties.
Mm-hmm.
The act or omission must be reasonably necessary for the purpose of resisting actual violence, threatened to him. Now, the classic situation in which that arises is where there's a thug immediately opposite you who threatens to hit you unless you do something.
Yes.
But that's the classic situation. But do the words resisting actual violence threatened to him cover a situation where you import goods, which is the act or omission in question, and when you do so, there is no, you're not, or you could be said that you're not resisting actual violence threatened to you. What you are doing is pursuing a course of conduct to avoid being subject to violence later in the light of the threat previously made the night before, in this case.
Well, my lord, I don't know that the word actual, as it's used in Section 47, really adds very much to the meaning of the section at all. I mean, it does appear to play a slightly clearer purpose in Section 48, because it says harm threatened to be inflicted upon him by some person actually present.
So well, forget about actual. Take a case where on Monday the defendant is told that unless he imports drugs to Bermuda, he will be beaten up.
Mm-hmm.
And he says, "All right, I will." He leaves the scene where that takes place, and he gets into a plane with nobody connected with the threat nor around, has the drugs on the plane, gets out of the plane. He could be said to be doing that in order to ensure that he won't be beaten up in the future. But can he be said to be importing for the purpose of resisting actual violence as opposed to importing for the purpose of ensuring that no violence is threatened to him in the future?
Well, my lord, I mean, that wasn't an argument that was explored in detail in the court below. And I mean, it seems a rather bizarre situation in which the parties find themselves on this appeal, whereby it seems to be the defense who are arguing that a particular defense was not available and the prosecution who are arguing it's obviously not what one expects from either side. I mean, I certainly recognize that the defendant in this case had an uphill battle in establishing that which he did was reasonably necessary from a factual perspective in order to escape violence. And, you know, the prosecution ran its case in part on the basis that he, even on his own account, had opportunities to break off from this course of conduct. But those are the factual issues. And in my respectful submission, what the judge had to determine was whether the defense pursuant to Section 40
just a moment,
legally available to the defendant. And it wasn't on the basis of the threats to third parties because they were not present with him, but it was on the basis of the threats that he said had been made to him. And let us not forget that he said that he had been kidnapped the night before he flew to Bermuda by some individuals who miraculously had an interest in sending a package to Bermuda the next day. And he already had that plan to travel to Bermuda. So it was a remarkable coincidence, one which the prosecution said was incredible and maintains was incredible. And then having been beaten thoroughly by these two men overnight and had very little sleep, he was then taken by them to the airport and put on the plane that he had already planned to travel on to Bermuda.
When he was getting on the plane and staying on the plane and getting off the plane, can he be said to have been resisting actual violence?
Well, the question is whether what he did was reasonably necessary or was arguably reasonably necessary. And
Mr. Richards, could you actually answer his lordship's question? Because I'm interested in.
Of course, I don't think that it ultimately that it would have been right to conclude that it was, but that doesn't mean that the defense wasn't available to him. There was no legal impediment to the defense, such as my learned friend contends.
Say,
this is Mr. Richard, that you read the word for resisting, you would read it as avoiding.
Well, I certainly see that there is a perfectly decent argument could be made that is how it ought to be read. And
But in any event, there's no complaint about how the case was left to the jury.
Well, I think in a sense there is, because I think my learned friend is saying that it ought to have been apparent to everyone that it didn't need to be left to the jury.
But that doesn't prejudice the client.
It should have been.
No, indeed, of course, it doesn't prejudice him in any way. But I suppose the point that I'm trying to make, my lords, is that the suggestion that Mr. Warner had fundamentally misunderstood the law relating to duress, and that if only he had told Mr. Davy that it was not available to him at all, Mr. Davy would have accepted that advice and promptly pled guilty, is predicated on her assertion that there was no available defense. And I agree that Section 48 wasn't available, but in my respectful submission, a component of Section 47 was, bearing in mind the defendant's account. Now, the Crown's primary answer to that was that he was lying, that it was a manufactured account, that there was no abduction by these two men, or any of the beating that Mr. Davy described. But equally, the Crown was entitled to put its case on the basis that factually he had opportunities to avoid what he was doing, but that doesn't mean that the defense was not legally available to him on the evidence that he gave.
Well, that depends on what is the true meaning of resisting. If
And
the
indeed why
argument
the
that I
word
was,
actual is there.
yeah,
Well, I don't, with respect, my lord, see that the word actual really makes very much difference. I mean, it's actual violence threatened, so it's threatened violence. I mean, you can't threaten pretend violence.
yeah, yes, you can have actual violence threatened when a man says, unless you give me something, I'm going to punch you in the nose. There's no actual violence, that's an assault. There's no actual violence
Yes.
until he does punch you in the nose. But if the position is that when it says the act or omission is reasonably necessary for the purpose of resisting actual violence, if that means doing something in effect to prevent the man from hitting you and doesn't cover taking an action which will avoid violence in the future, if that is the true construction of Section 47, which is, I think, a matter of law, we get to the curious position that the judge, in fact, gave a summing up which left open a defense that wasn't open, which was to the benefit of the accused, but which the jury did not, in fact, accept. Discuss.
Yes. Oh, I'm sorry. Discuss is a question. Yes, I see.
Right, sorry, it's a.
No,
I mean, is that analysis right?
Yeah. I see that it is, my lord. But I mean, the suggestion here, as I understand it, by my learned friend, is that on the basis of Zegelis, trial counsel should have apprehended that there was no available defense in this case, and that he should have told his client that, and if he had, his client would have pled guilty immediately. In my respectful submission, there are a whole host of indications that is not correct. The errors that my learned friend says Mr. Warner made, in my respectful submission, are not as clear as she suggests, because whilst it's correct that Section 48 was not engaged, as I've endeavored to argue, and as my Lord President put to her earlier, there is a part of Section 47 which it appears would properly be engaged. And then, of course, there is the question of Section 29 of the Misuse of Drugs Act, which was also put in issue by the defendant in the course of his evidence. But before I come to that point, nowhere in Zegelis do I understand this court, as then constituted, to have said that the Section 47 and 48 defenses should not have been left. And in my respectful submission, it would appear that Mr. Zegelis was in no better position to rely upon the Section 47 defense than this defendant was. What this court said in Zegelis was not that the judge shouldn't have given the 47 and 48 directions, but that he shouldn't have given the extra direction that he gave about the drugs not, in fact, having been intended by that defendant for this jurisdiction. And perhaps it'll assist if we go to the judgment in Zegelis to just clarify that. So it's at the first tab, I believe, of the joint bundle of authorities. And on the third page of the judgment, which is also page 3 of the bundle, the court sets out the 2 sections. And it says that the direction was given in accordance with those sections. And it then says at paragraph 14, in addition to these 3 statutory defenses, the judge said there was one other statutory defense at issue in Zegelis, which does not arise here. That's Section 39, extraordinary emergencies, but we don't need to worry about that for the purposes of this case. So continuing at paragraph 14, bottom of page 3, in addition to these 3 statutory defenses, the judge said this about a possible 4th defense, which would arise if it was accepted as it should be, that the drugs were never to be for Bermuda, that they were going to Latvia or at least Denmark Channel. So the defendant was just passing through because he was driven in here by a storm which damaged his boat. In my view, that is not a defense in law, said the judge, but he called it an emotional defense, and bottom of the page, he left it to the jury. Now, the court says further down the next page, paragraph 19, we should say at this stage that in our view, the judge ought not to have left this issue to the jury when he had directed them that, in his judgment, it could not provide a defense in law. He should have taken the responsibility of directing the jury that they could not acquit on that basis. However, we cannot say that by leaving it to the jury, judge prejudiced the appellant, rather the reverse. So even though it wasn't material to the disposition of the appeal, the Court of Appeal did expressly deprecate the drugs not meant for this jurisdiction direction. They did not so deprecate the directions pursuant to either section 47 or 48. They were satisfied that those directions had been properly given by the learned judge. And I think it's the same judge, if I recall correctly. I believe Zegellis was also tried by Mr. Justice Graves. So it's not correct. And my learned friend hasn't said this expressly, but to the extent that she relies on Zegellis as a clear indicator that these defenses are legally unavailable, that's not actually what the judgment says. And it's also not correct that it says in terms that common law duress was not available to the appellant in this case. I in fact, addressed the learned judge to the effect that by implication, it excludes common law duress, and he accepted that submission. But it doesn't say in terms that it's not available at any point in the judgment in Zegellis. And I just want to find that discussion for the benefit of your lordships. It may cause me some embarrassment because I think my impatience at that point in the transcript, for which I apologize. Forgive me one moment, my lord. I had the page reference, but it seems I'm I shall not take up too much more of the court's time.
But common law duress wasn't left to the jury, was it?
It wasn't, and it was right that it should not be.
Right.
But I think my learned friend is trying to suggest that Zegellis made all of this completely clear, and that by even attempting to argue that common law duress ought to be left, Mr. Warner had somehow demonstrated that he had completely misunderstood the law and misadvised Mr. Davy. And in my respectful submission, that simply does not follow.
No.
I have found the passage I was looking for.
So what appears to be the position, I'm just looking back at Zegellis, is that the judge directed the jury in accordance with section 47 and section 48. This court didn't say that he shouldn't have done, and appears to have proceeded upon the basis that if, as the defendant said, the threat was made over the telephone, see paragraph 3, by the chap he was taking the boat, the chap for whom he was sailing the boat from Trinidad. This court appears to have proceeded upon the basis that if that threat was made over the telephone, obviously in circumstances where the man on the telephone was nowhere near the defendant on the boat, that could amount to a defense under section 47. Because at 16 of the judgment, it says the judge gave a detailed further direction on the terms and application of section 47.
Yes.
Burden was on the prosecution to prove that the violence was not threatened to the defendant. His family were not present, and so that part of the section fell away. And if it was, that the act done by the defendant was not reasonably necessary in order to resist the threatened violence. And this court didn't say he should have done that. So
it didn't say he should not have done it.
Yes, this court did not say that he should not have done that.
Yes.
So,
in fact, it did say that he should not have given another direction. So,
yes, it did.
Yeah.
So Mr. Davy's counsel was entitled to proceed upon the basis that there was a defense that could properly be put to the jury, that the threat to Mr. Davy himself, although not made when he was on the aeroplane or the moment he got onto it or the moment he got off it, that threat made the night before could amount to a defense under section 47.
Yes, my lord.
And you say he can't possibly be criticized for putting forward an argument that appears not inconsistent with the decision of this court in Zagalis.
Yes, exactly so, my lord. And equally, in relation to the submissions that he made, that my learned friend criticizes in respect of the availability of common law duress. He was wrong to invite the court to give a common law duress direction, and I don't suggest otherwise. But it was arguable because, contrary to what my learned friend says, Zagalis doesn't expressly say that common law duress is not available, and it is certainly not unheard of, nor is it evidence of incompetence for defense counsel to reach a little in their submissions. I defended some cases back in the midst of time myself, and occasionally one is quite ambitious in the submissions that one makes to the court. And perhaps my learned friend has had that experience as well. The fact that Mr. Warner was ambitious in asking for a common law duress direction doesn't mean that he had clearly fundamentally misunderstood and misadvised Mr. Davy as to the nature of his prospects. So, my lord, there is a colloquy between myself and the court, which is reflected at page 233 of the record of appeal. And in fact, we can start at the top of the page, because I had obviously had some discussions with my learned friend, Mr. Warner, and he had intimated that he was going to invite a common law duress direction. And it may be, I said to the court, that my learned friends will seek to persuade you, Lordship, to give a common law duress direction as well. And he says, how can I do that? It's code country. I say, I agree with your Lordship. I'm just anticipating his submissions. Court, all right, respectfully, I say, court again, and the Court of Appeal has upheld these directions. Yes, it seems to me, in more than one case, which I have done, court again, then me, yes, and it seems to me respectfully, my lord, that if, and then the court, The case I referred you all to was Zegellis, and this is actually referenced in the transcript, my lords. The learned judge had talked to us all about Zegellis on day one when Mr. Warner first attended, and Mr. Richardson was also present, and that is confirmed by Mr. Warner on page 236 of the transcript. But just continuing from where we had got to, I say Zegellis, the court says Zegellis. I say rather impatiently, for which my apologies, if your lordship would just let me finish the sentence, I'm agreeing with your lordship. The court, right, Mr. Richards, it respectfully seems to me that had your lordship been required to give a common law direction, which you didn't in Zegellis, the Court of Appeal would clearly have said so, and they didn't, and then the court agrees with me. So
Right.
I make that point simply to say that they don't expressly say common law duress is not available. So Mr. Warner was entitled to have a go, in my respectful submission. But the implication, given what they did say, is that it's not. And that argument, I would say respectfully, was found to be correct by the learned judge.
So you say that there was a section 29 point anyway.
Yes.
Because Mr. Davy said he didn't know what he'd been given were drugs. And if that was correct, he had a defense on that basis.
Yes.
Forget about threats.
Yes.
And you also say that there was a possible defense in relation to the threats to him under section 47.
Yes.
Because in effect, that defense was left under Zegellis. And just about left in this case.
Yes.
Right.
I mean, things respectfully might be different if Mr. Davy had given this account or something like it in the course of his police interview, but he didn't. He went no comment substantially. He answered a few basic personal details, but he certainly didn't give any account about being kidnapped or anything like that. And of course, his failure to mention those facts wasn't something I was able to rely on in trial as a result of the words of the caution in this jurisdiction.
Yeah.
But if he had given this account or an account of these sorts at an early stage and pleaded guilty, then it may well be that the court would have given some credence to this account. But the reality was that it was an extraordinary, and that's the judge's words, an extraordinary defense. And when the judge used those words, in my respectful submission, it was perfectly apparent that he wasn't passing comment on Mr. Warner. He was passing comment upon the defendant's evidence, which the prosecution was entitled to invite the jury and in due course the judge to wholeheartedly reject. And we will come on to it in a moment, but in my respectful submission, it is clear from what the learned judge did say, albeit that he didn't use the language that my Lord President used earlier, that he was, in determining what the appropriate sentence was in Mr. Davy's case, completely rejecting the defendant's case, that he had been subject to any level of duress, much less one that could afford him an acquittal. So from what my Lord President has said, I may be that I don't need to say very much more about the section 29 point. It is rehearsed at paragraph 12 of my written submissions. And if the court wants me to go through it in any more detail, then of course I'm more than happy to do so. But you have the page references to the transcript, both the relevant sections of the defendant's evidence and what the learned judge said about it, which I think is actually quite close to where we were just now, because he obviously recognized that he was obliged to give a direction in accordance with section 29 in light of what the defendant had said about his state of awareness. So quite aside from everything that my learned friend has said about duress, that too, as my Lord President apprehends, it's my submission, was a viable defense arising on the evidence that the defendant had given. and necessarily required a direction to the jury. It may not have been factually strong. The defendant's evidence in support of it may have been incredible, but that's not Mr. Warner's fault. That is the defendant's fault. And in my respectful submission, it is the defendant, now the appellant before your lordships, who ultimately has to accept responsibility for his plea, which was not one of guilty, but one of not guilty. And that fell into a pattern of behavior, in my respectful submission, which is still apparent before this court today. And it may, in fact, appear to the court that Mr. Davy is not detached from what is said on his behalf. He has, in fact, clearly been engaged in these proceedings, because on more than one occasion he's raised his finger in order to speak further with Miss Christopher, and clearly been quite anxious to do so. So he is not, in my respectful submission, sitting back and taking no interest. He's clearly engaged, and there is no reason to believe that he would not have been engaged in making the decisions himself at the earlier stage of these proceedings. Well, as I say at the very outset of my written submissions, the appellant, in my respectful submission, has throughout his time in Bermuda on this occasion tried to evade responsibility for this offending. That started out in the airport when he realized that he was about to be discovered and he ran off. Then he mounted what I still maintain is a fantastical defense before the jury, for which he ultimately, in my respectful submission, is responsible, and it was clearly, resoundingly, and swiftly rejected by the jury. And even now, before your lordships, I say he is trying to evade at least a portion of his deserts for that crime by seeking to blame his trial counsel for the fact that he had a trial. And that, in my respectful submission, does not stand up. The criticisms that my learned friend is able to level at Mr. Warner do not go anywhere near supporting the proposition that Mr. Davy only pled not guilty because Mr. Warner made a mistake. That is ridiculous, in my respectful submission. Now, I'm sorry, I in fact intended to elicit the court's indication as to whether I needed to say anything further about Section 29 before I moved on.
Well, speaking for myself, I don't think so. Section 29, given that Mr. Davy was saying he didn't know that the package contained drugs, it was plainly necessary, which would be a defense if it were true, plainly necessary, and itself would justify, it might be thought, Mr. Warner continuing to defend him on the basis he wasn't guilty. And it would certainly require a direction which the learned judge gave.
Yes. Thank you, my lord.
There's no complaint about that direction.
Well, my learned friend doesn't mention it at all, my lord.
No.
And that's significant, because she is arguing before the court that he had no defense and he should have pled guilty. But he did have a defense. He said he didn't know what was in the package. And that was a lie. The Crown is quite clear that it was putting its case before the jury on the basis that he did know, or at very least had reasonable grounds to suspect, to use the language of Section 29. So I am not for a moment suggesting that it is true that the defendant didn't know what was in the package. But he went into the witness box and gave sworn testimony to that effect before the jury. That assertion amounts, if true, as my Lord President says, to a defense. So to suggest that Mr. Davy only had a trial because Mr. Warner didn't understand duress is preposterous. Mr. Davy wasn't only running duress, he was also running knowledge.
So in those circumstances, you're saying that the duress aspect of it becomes rather an irrelevant sideshow.
Well,
Yes.
I think maybe it does, my lord. I mean, I don't agree with everything my learned friend has said about duress, so I've been unable to resist the temptation to say something about it. But I do agree with your lordship that even in the absence of, even put it another way, setting aside the debate about the precise ambit of section 47, the knowledge element is sufficient to dispose of any suggestion that responsibility for Mr. Davy's plea is Mr. Warner's and not his own.
Right.
So moving on then, I think I'm now at paragraph 19 of my written submissions. In my respectful submission, judge was entitled to come to his own view of the evidence. This is dealing with what my learned friend has said about residual duress, which I think I probably do still need to address, notwithstanding the colloquy that I just had with
Yes.
Justice of Appeal Bell.
Duress with a small d.
Yes, I'll try to use that nomenclature since it's what we seem to have adopted. Yeah. The duress with a small d, in my respectful submission, and I want to make sure that I've understood the court, but I detected with respect that there may be a slight difference in approach as between the members of the court in terms of their questioning of Ms. Christopher earlier. I respectfully adopt what my Lord President has said, that when the jury's verdict does not necessarily reveal every fact relevant to sentence, it then properly becomes a matter for the judge to make what he does of the evidence. So my learned friend, I think, is right that in the circumstances of this case, on the issue of duress, the jury's verdict did not necessarily mean that they had found the defendant's account to be completely untrue, although that, as I've said, was the prosecution's primary case. That they may have thought that it's possible that there was some level of threat to him, but that it wasn't one that legally justified him acting as he did. And since the verdict of guilty does not clearly indicate by itself which of those routes to conviction the jury took, in my respectful submission, the court was entitled to make its own assessment of the evidence. And that is something that the prosecution referenced in its sentencing submissions, which I have dropped on the floor. So if you will excuse me, my lords, for one moment.
Yes.
So this point is touched upon at paragraph 12 of the sentencing submissions, which my Lord Justice of Appeal Bell put to Ms. Christopher earlier. And I have to recognize, my learned friend, Ms. Christopher, is correct that the opening sentence of that paragraph, it is submitted that the defendant is wholly to blame for his role in these offences, is quite commonly present in sentencing submissions filed by the prosecution. I have not used it every single time myself, but she is right that there are certain turns of phrase that do quite frequently find their way into these documents. But the rest of the paragraph in my respectful submission demonstrates that there's been some thought given in this instance to the use of that phrase and is tailored to the particular circumstances of this case. I said earlier that the fact of the verdict by itself gives no indication as to what route the jury took to their verdict, but perhaps other factors may give some indication. The speed, as I said in the submissions, with which the jury reached their verdict is a good indication, I put it no higher than that, that they roundly rejected the defendant's evidence, as opposed to maybe finding small d duress. And then it continues in this vein. The court is in any event entitled to take its own view of the evidence, and should it is submitted easily and safely, conclude that the defendant's evidence was wholly concocted in a desperate and transparent attempt to elude justice. Now, as my Lord Justice of Appeal Bell has already highlighted in the course of a question I think he asked of my own friend earlier, the learned judge clearly indicated in the course of his sentencing remarks that he adopted the Crown's sentencing submissions. He in fact said that twice. The first such reference is on page 385 of the Record of Appeal at line 9. I say this is not a difficult sentencing to be done in this case, and I could simply adopt all the submissions of the Crown as my own. I see no reason to differ from them or to divert from them in any way. And then he goes on to speak in terms of the numbers that the Crown had put before the court. And then subsequently, the next page, he says at line 23, so I return to the submissions of the prosecution. And as I said before, I will adopt them as my own reasons because I hold for myself the same reasons for his sentencing. Now, I say this not to brag about the fact that the Crown's submissions found favor with the court. My point is that clearly in saying that so emphatically, the learned judge can only be understood rationally to have been rejecting any notion of small d duress, because the Crown's submission on sentence was that the defendant's evidence was wholly concocted in a desperate and transparent attempt to elude justice. And that remains the Crown's contention before your lordships. And even though I have to recognize that the trial judge didn't use a formulation exactly as my learned friend, as my Lord President put to Miss Christopher, I think, a couple of times during the course of his submissions. He didn't, in his own language, articulate his rejection of the defendant's evidence. The fact remains, in my respectful submission, that from what he said at those two sections of the sentencing remarks that I've taken you to, alluding to the prosecution's submissions on sentencing, which in addition to being submitted in writing, had been addressed to the court only moments earlier, the learned judge must logically and reasonably have come to the conclusion that as he was entitled to, he could reject entirely the defendant's assertions of small d duress or any kind of duress, and sentence him on the basis that there was no such mitigation present in this case. And I mean, my lords, I think have already got the point about Downer. That clearly is a case where there was some real tangible evidence to support the contention that there was any level of small d duress to the appellant concerned. And there was no evidence to corroborate any of the appellant's assertion supporting his purported defense of duress in this case. None whatsoever. In fact, there was evidence to contradict it because despite this substantial beating that he said he had received only the night before, no injuries were detected, and he managed to sprint across the airport car park and evade capture, as your lordships are aware. So in my respectful submission, whilst my learned friend is right that the jury's verdict did not necessarily mean that they found the defendant's account to be untrue, the judge was entitled to make his own assessment once they had rendered a verdict. He clearly did, and having done so, suggestion that credit should now be afforded the defendant for small d duress is misplaced, and it would be wrong with respect for this court to substitute its view on that point for the judgment of the learned judge, because you haven't had the benefit of sitting through the trial, you haven't heard any of the evidence. In particular, you haven't been able to observe the defendant as he testified, which of course the learned trial judge did. And so if you're satisfied, as I respectfully submit you should be, that he clearly did address his mind to that issue and made the determination which clearly he must have made in my submission, then you should leave that determination undisturbed, because it was properly a matter for him and should not be revisited in this forum.
Mr. Richards, I'm not sure it matters at the end of the day, but I'm curious about the proposition that it should have been open to the judge to form his own view on the question of duress for the purposes of sentencing. If indeed the matter had been properly left to the jury on the basis of Zagalis, how is it that you would envisage that the judge could have sentenced on the basis that there was in fact duress? After the
Well,
jury
he wouldn't be sentencing on the basis that. Oh, I'm sorry, my lord. I thought you'd finished.
Yes. The jury
He wasn't.
having rejected that proposition.
Well, the jury didn't. I think I have to agree with Miss Christopher on this point, Malone. The jury didn't say that there was no threat at all. They said that there was no defense of duress. That's the necessary implication of the verdict of guilty. So let us say, posit a hypothetical. Supposing that the defendant had pleaded guilty and said, perhaps a little bit like Mr. Downer did.
No. That's a different matter, because we'll then proceed on the basis of a guilty plea. But here,
but this is important, my lord, because
we don't have that context. Here we have the jury having had to try the very issue and rejected the defense, as it was understood by them, of course.
Yes, but all
the concern
is was the function
line proposition that the judge could then have sentenced on the basis of his acceptance that the defendant had acted under some kind of threat.
Yes.
Let us not call it duress. But where would that have led the judge?
Well, I think that and I'm sorry to go back to my hypothetical, but I think it is important, my lord, because if the defendant had said, look, I was threatened, and I part of the reason that I did this was because I was threatened, but I accept that that doesn't afford me a defense, and so I'm pleading guilty, then, of course, it would be up to the Crown to decide whether or not it accepted his plea on that basis.
Oh, yes. And you could have had a Newton hearing and so on.
Exactly. And then it would.
The situation here at all.
But, my lord, I think it elucidates the proper approach to this situation, because if that were what had happened and the Crown had said, no, we don't accept that plea, we say there was no threat at all, the judge would have had to make an assessment of the evidence without any assistance from a jury. And he would have had to have heard the defendant would have been cross-examined, and he would have made his own assessment of whether...
Right, there's an entirely different scenario. My concern was that the proposition that in this case, in the particular circumstances of this case, it was required that the judge should have considered for the purpose of sentencing and decided for himself whether or not he accepted this defense of duress in any shape or form.
Well, I think, if I may give what I suspect Mr. Richards' answer is, be it assumed that Section 47 afforded a defense if there was a threat of violence against Mr. Davy, even though the threat was made the night before, and what we're talking about is what happened on the airport, in the airport and on the aeroplane. But on the assumption that such a threat gave rise to a defense, potentially gave rise to a defense under Section 47, the question then would be whether the act or omission for which the person is said to be criminally responsible, namely the importation of drugs, was reasonably necessary for the purpose of resisting the threat that was made to him the night before. And the jury could have come to two different conclusions. One, that there wasn't any threat, so it didn't matter at all whether what he did was reasonably necessary for the purpose of resisting it, because there wasn't one. Alternatively, they could have come to a conclusion that there was a threat, but what he did was not reasonably necessary for the purpose of resisting it. If they came to the latter conclusion, it might be arguable that the existence of the threat, although not constituting duress with a capital D, because all the provisions of Section 47 have not been satisfied, might nevertheless constitute duress with a small d as a mitigating factor in relation to the offence which he committed.
I accept the hypothesis, President. My difficulty is, where does the judge go in addressing that issue, if it is an
Well,
issue?
I think what he does is to say, the jury have rejected your defence. I can't tell whether that was on the footing that you never had a threat of any kind, or whether it was because of what you did wasn't reasonably necessary for the purpose of resisting it. But you say that you were subject to duress with a small d, and in order to determine whether and if so to what extent I should take that into account for the purpose of sentencing, I must reach a conclusion, and only I can do so, as to whether there was duress with a small d.
And then what? Would that
Well,
have
either
entitled him to being
either he
acquitted?
says, I'm quite satisfied there was no duress with a capital D, and I'm quite satisfied there was no duress with a small d, so we can forget about duress with whatever form of lettering. Or he says, I am satisfied that there was in fact duress with a small d, and I either will take that into account or won't take that into account by way of reduction in sentence.
But either way, he's got to reach a conclusion in relation to small d duress.
I think that's what you're saying, Mr. Richards, is it?
Yes, it is. I say that he was entitled to reach a conclusion, and he did, and he didn't articulate it as clearly as my Lord President has, but he indicated on more than one occasion that he was adopting the prosecution's submissions, and the prosecution's submissions were that duress was a fantasy, totally untrue, and not that there was no residual threat, and that it should be discounted. And in my respectful submission, in those circumstances, the court was perfectly within its rights not to afford any discount for any element of duress. And it would be quite wrong for this court to substitute any doubt it may have on the matter because it hadn't heard the evidence, it didn't see the defendant testify. And so, in my respectful submission, I think I've said everything that I can on that point. And I think I probably better move on to my learned friend's other submissions about the general level of sentence. But I'm happy to.
Yes, for my purposes, that's fine. We will have to determine, I think, whether or not, as a matter of law, the judge could properly have proceeded to have sentenced in the way we have discussed. But that's a different matter.
I mean, the only other thing I can do to.
I certainly have my reservations about that. I think that's clear enough.
Well, I think the only other thing I can do to perhaps assist the court then is maybe to, with the court's leave, take you to a section of Archbold. I didn't apprehend that this particular issue was going to concern the court, so I didn't put anything in to reinforce what I said in paragraph 12 of the written submissions. But I can, with the court's leave, take you to a paragraph of Archbold that I think does give clear authority for the approach that both my learned friend and I are acknowledging the judge was entitled to take. I think my learned friend's issue really isn't that he wasn't entitled to take a view. It's
yes, well, I would find that helpful.
You would, my lord.
Yeah.
Yes, I would.
Okay, so it's in the 2018 Archbold. It's paragraph 593. Now I can email Mr. Coelho a scan of that if the court needs me to.
Yes, please.
Yes, please.
Okay.
Yeah.
What was the reference, Mr. Richards?
593 of Archbold, Mr. Coelho. I'm just sending it to you now.
2018 edition.
I've sent it to Miss Christopher as well.
Have your lordships received it?
Not yet.
No. You sent it by email?
Yes.
It's just come.
Oh,
So, my lords, if you have it before you now, it's the section entitled Interpreting a Jury's Verdict that I wanted to make reference to. And it says there, if there is, am I ready to, are your lordships ready for me to start reading, or do I need to give a moment?
I have it all.
Okay, so if there is only one possible interpretation of the jury's verdict, then the judge must sentence on that basis. Where there is more than one possible interpretation, the judge must make up his own mind to the criminal standard as to the factual basis upon which to pass sentence. And if there is more than one possible interpretation and the judge is not sure of them, then he is obliged to pass sentence on the basis of the interpretation, whether in whole or in part, most favorable to the defendant. So I think that the proposition upon which Ms. Christopher and I agree is that the verdict of guilty in this case did not necessarily of itself indicate whether the jury disbelieved duress in toto, or merely whether they thought that though there may have been a threat, what the defendant did was not reasonably necessary to resist it. And because the verdict doesn't indicate which of those possible versions is true on their assessment of the evidence, it was for the judge to decide on his assessment of the evidence, giving the defendant the benefit of any doubt, but with the benefit of having heard that evidence himself. And in my respectful submission, although he didn't articulate himself in the way that my Lord President has suggested that he might have done, and although it would have been better if he had, given that he twice said that he adopted the Crown's submissions, and the Crown's submissions were that he should reject the defendant's evidence in its entirety, then clearly that is what he had done, and he was entitled to a sentence on that basis.
Mr. Richards, I'm looking at it on my phone because otherwise I'll lose everybody forever here. But so that in relation to the position where the judge is not sure, it's only if the judge is not sure that he is obliged to give to pass sentence on the basis of the interpretation most favorable to the defendant. Is that right?
Yes. So he's obliged to apply the criminal standard. So if he thinks that there may have been a threat, then he ought to sentence on the basis that there was. But if he's sure that there wasn't, then he can properly sentence on the basis that there wasn't.
Right.
And that is the situation that I say was presented here.
And to complete the proposition, this discount wouldn't have the effect, of course, of the statutory defense, but it could be a significant discount. Is that the idea?
Well, I suppose that would then get into
some threat.
Yeah, I mean, that would then get into an exercise of discretion. It'd be up to the judge to think how serious it was. And one can understand why, in a case where somebody has clearly been shot, as in the case of Downer, the court thought that was worth something. But no corroborative evidence of anything of the kind in this case. It was just the unsupported assertions of the defendant, which the court was entitled to reject.
All right, thank you.
So the rest of my learned friend's submissions, as I understand them, are based on a line of authorities dealing with drug sentencing in this jurisdiction. And with the greatest of respect, she has, in my submission, sought to rely upon predominantly older cases, including some that predate the statutory 27B uplift, which really aren't going to assist this court at all. This court has had recently occasion to revisit sentencing in commercial importations of Schedule 5 substances, namely those that attract the uplift, of which both cocaine and heroin are such substances, and has clearly indicated, first of all, in the case of Brown, which I think was a judgment of the previous president, and more recently still in the case of Swan, which I think was a judgment of Justice of Appeal Smellies, that the starting point in cases such as this, importations of commercial amounts of these sorts of substances, is not going to, absent extraordinary circumstances, be less than about 12 years. And that's exactly the starting point that the learned judge in this case took, as the court has already apprehended from the sentencing remarks. So if you look at paragraph 56 of the, page 56 of the Joint Authorities Bundle, that's where the sentence appeal is first addressed by the previous president in respect of Brown. The sentence in that case was 15 years imprisonment for importation of some 894.6 grams of cocaine. The court references the case of Stewart and the case of Cox, and concludes paragraph 28 of the judgment by saying that in Cox, Justice of Appeal Mantell said that it was well recognized that in cases of commercial importation of crack cocaine, the starting point following a trial was unlikely to be less than 12 years. Court then references a couple of other cases, Bean and Simons, where there were sentences of 15 and 12 years, and the case of Tucker and Simons, where the proper procedure for application of the Section 27B uplift was reviewed by President Zaka. Then at paragraph 31, the learned judge correctly followed the procedure in the present case, although absence of previous convictions is not ordinarily regarded as a mitigating factor in contested drug importation cases. So the appellant might be regarded as fortunate to have had the basic sentence reduced from 11 years to 10. Well, in this case, the sentencing judge took 12 years as the appropriate starting point, and in my respectful submission, there is no proper basis to criticize him for having done that in light of what the court said in Cox and reiterated in Brown. She observed that drug abuse is prevalent in Bermuda and that the message needs to go out that the offences of present kind will attract substantial sentences. I agree. That plainly was the view of Parliament, who have imposed a maximum penalty of life imprisonment for this offence, and in cases like the present, where a determinate sentence is passed, 50% uplift. It is true that the street value of the drugs on the present case was substantially less than in Stewart. On the other hand, this was a commercial importation, and I note the observation of Mantell in Cox. In the circumstances, I do not think the sentence of 15 years was manifestly excessive. Well, here, of course, the street value of the drugs was higher than in the Brown case.
What was the value in the Brown case?
I believe it was 209,625. I have that written down somewhere, but I will see if I can find that in the judgment.
Yes, I've been looking for it and can't find it.
That must be. No, I can't find it either. Now that is interesting. It's not there. Well, the Crown sentencing submissions, which page 395 of the Record of Appeal, indicate that the value was 209,625. Now, I must have got that figure from somewhere, but it does appear.
Sorry, what was the question?
I believe my Lord President's asking me what the value of the drugs was in Brown.
Well, doesn't that appear in paragraph 28 on page 56? In the present case, the quantity
Oh, I'm sorry, yes.
Yes.
So I must have done the arithmetic. Yes, I see. So I added 95,000 and 132,000. Yeah, so that's where I've got my 209,000 from. It doesn't actually.
Yeah.
In fact, the total was actually slightly higher than I stated in the Crown sentencing submissions. I'm still mystified as to exactly where that figure came from, but it seems as though the total value was. Oh no, I see. I'm sorry. So the range that the court accepted in Brown seems to have been between a low point of 95,700
and 132.
132, and my Lord Smelly has already indicated what the Act provides as taking the highest value that the court accepts. So I'm afraid I don't know where the figure I quoted earlier has derived from. It must be wrong.
But in any event, we're dealing with a substantially higher value.
Yes, I mean, that is the fundamental point, my Lord, yes. And not actually a substantially higher sentence. And it's a little higher. She's the judge in this case has taken a starting point of 12, whereas the judge in Brown took a starting point of 10. Considering the difference in value, I find it very difficult to see how this appellant can complain that his starting point is in any way excessive. And my learned friend seems to suggest that that the value doesn't matter. But I mean, respectfully, it must have some relevance. It may not be the only factor that one looks to. But Mr. Brown, in my respectful submission, was engaged in essentially similar conduct. He was on his own, bringing the drugs in through the airport. It wasn't a case of it being absolutely clear where he should be positioned in the hierarchy of the crime as a whole. And perhaps it isn't in this case either. It's often difficult in these importation cases to say quite how high up the food chain the defendant with whom one is dealing is to be positioned. It seems improbable, perhaps, that architects of drug importation schemes are going to put themselves at the risk of carrying drugs and will usually engage others to take those risks. But it's quite clear in my respectful submission that even though that will occasionally mean that vulnerable persons are recruited to this task, they won't receive significant sentences of deterrent imprisonment. This court has routinely upheld such sentences in such cases. Brown is a clear example. And in my respectful submission, to the extent that there is any differentiation properly to be made between this case and Brown, it doesn't assist this appellant. The value of the drugs in his case was significantly greater, and the sentence was only slightly greater. And so for that reason, in my respectful submission, it's impossible to criticize it. The sentence in Curtis Swan, which is the judgment of my Lord Justice of Appeal Smelly, is somewhat higher. I think that was 21 years imprisonment in that case. And I think perhaps in the Swan case, one can properly say that there was evidence that a little bit more clearly established what Mr. Swan's role was in the enterprise, bearing in mind the evidence surrounding his collection of the drugs and the other chemical elements that were necessary to extract from the packing paper. So it was a bit more sophisticated than simply carrying the drugs through the airport, as in Brown and as in this case. And so it makes sense that this sentence, Mr. Davy's sentence, would lie somewhere in the range between the sentence in Brown and the sentence in Swan, in my respectful submission. And I don't respectfully feel it necessary to respond at great length to the submissions that my learned friend has addressed to the other cases in the joint bundle of authorities, because in my respectful submission, the best guidance that the learned sentencing judge had was the decisions of this court in Brown and Swan, those being two most recent and relevant importation cases that were available to him. And in my respectful submission, the conclusion that one can very easily derive from reference to those cases is that there was certainly no justification for taking a starting point of less than 12 years in Mr. Davy's case. Indeed, I would respectfully submit that it may well be that a slightly longer starting point could have been justified, but obviously that point is not one the court needs to decide. The question is whether or not the sentence was manifestly excessive, and plainly in my respectful submission, for the reasons that I have endeavoured to elucidate, it was not. And so unless there are any points upon which I can assist your lordships further, I think those really are my submissions.
And in Brown, it was cocaine, not heroin. Yes,
and I think my learned friend is right that historically there was perhaps a greater difference. The court's approach to those two drugs was a little more different than it is now. I mean, the legislature clearly sent a message by enacting Section 27B and Schedule 5 that it considered that the sentencing for both was low and needed to be increased by 50%. And the approach to both, well, all Schedule 5 substances, but in particular cocaine and heroin, has become much more consistent in my respectful submission latterly. But I don't respectfully suggest that there is any greatly significant distinction to be drawn. Justice of Appeal Bell indicated clearly the sentencing judge in this case took the view that, and I think he actually articulated this in the course of his sentencing remarks, that heroin was a bit more serious than cocaine. But at the end of the day, I don't really see that that's a distinction that needs to detain the court significantly.
Right. We've moved away from the proposition that in general heroin sentences should be 50% more than cocaine.
It seems to me that we have, and that really the approach is that both are very harmful drugs, and that and uplift is appropriate for both and not just for heroin. Right. And as regards the point that my learned friend makes about purity, I mean, as Justice of Appeal Bell has already touched upon, the purity obviously is an integral part of the calculation of the value. And it's apparent that the purity of this heroin was actually slightly above the average purity, but that the police drug expert had nevertheless assumed a lower purity at the point of sale, and thus justified his calculation of just over, well, a little over $700,000 worth in value. So if one takes the value, which is perhaps the best guide in terms of comparing one case to another, particularly when you're dealing with slightly different, although roughly equally harmful drugs, then clearly you are, in the course of the exercise as a whole, taking some account of the purity of the drug, because it's a factor in that calculation. So in my respectful submission, clearly this case, with the high value that it did involve, called for a longer sentence than Brown. One can understand perhaps why it resulted in a slightly shorter sentence than Swan for the reasons I've given. And so the sentence of 18 years after application of the 50% uplift is wholly unassailable and should not be disturbed.
Thank you. I don't know whether either of my colleagues have any questions.
No, nothing further.
Thank you very much.
Thank you.
Thank you, my lords.
Ms. Christopher, anything by way of reply?
It's Christopher.
You're muted.
I do have an issue with the Section 29 point that is being made. The Section 29 defense was not part of the case that Mr. Warner was actually running. So I went, while we were discussing various points, I went through the record to ascertain what Mr. Warner said. And then when it was asserted that he didn't know what was in the package, and Mr. Warner believes that page 146. Let me start here. When it became a real issue, Mr. Warner did not directly deal with knowledge of what was in the package. Mr. Warner dealt with the fact that he said he packed the package, or he packed the package in the suitcase. But the issue with respect to him knowing what it is all came out in cross-examination. So it's not the case that Mr. Warner was saying, was running the defense of knowledge. Safe to say that when it was raised by the way in which my learned friend questioned him at page 166 of the record, then it was an issue. I'm just looking for the.
Sorry, can we just go 166 of the record?
Yes.
And what should we look at?
The cross-examination of Mr.
Page 167, Ms. Christopher,
Yes.
line 4. Isn't he saying he didn't know what it was?
Correct, but that was only raised in cross-examination. The point that I'm making is that it wasn't the case that he was running. I mean, it's a natural incident of the fact that it wasn't him and he was under duress, that he didn't know what was in the package. But it cannot be said, I don't think, that Mr. Warner was running this case of Section 29. So it's not the case that it can be said.
The appellant is saying that he doesn't know what was in the package.
Correct, but it's not the case that the defense.
That's
Was
his
what-
case. Whether or not Mr. Warner has made submissions in regard to it, that's still this appellant's case, is it not?
Yes, but it's clear from the way in which the case was presented that Mr. Davy, certainly on the basis of the way in which Mr. Warner had presented his case, was not relying on lack of knowledge to run his trial. He was simply relying on the defense of duress that he felt existed. But there's nowhere, and I looked to see, like I said, Mr. Warner did elicit from him that he had packed the suitcase, but I noted that it didn't go further for Mr. Davy to say that he did not know what was in the package. So it wasn't the case that was being run. And then I noted when
I don't understand your distinction between the case that was being run and Mr. Davies' actual evidence, which was that he did not know what was in the package.
at the heart of the position of the defense is that the defense of duress as a statutory defense should not have been run, right? And I would add that as far as I can see, that was the only defense that Mr. Davy was running.
So what's the effect of him giving this evidence that we see on page 167?
That was a question that was raised.
And what is the effect of it?
Well, it was a natural incident of it. And then Mr. Richards is the one who suggested that it be put as a as to the jury in the judge's summation at page, I believe, 261 of the record. So I'm simply saying that it was not, as Mr. Davy understood it, he was going to be running a defense simply to say that he had no knowledge. As Mr. Davy understood it, he's running a defense of duress. And when questioned by the prosecutor, he said that he didn't know what was in it, but it hadn't been part of his sort of defense. In fact, I'm not even clear. I believe there was a defense statement. Let me see if it was in the defense statement.
There was.
Was it?
I concede that it wasn't in the defense statement, Mike.
Right. So this was all an issue raised by Mr. Richards. So I just would humbly say
That I do not concede, but I will leave it to your lord.
well, I pointed the court to the passage, and I've
Mr.
indicated.
Richards, repeat that. I didn't hear it.
I'm just saying I don't accept that this is a defense somehow of my devising. I'm putting to the defendant that he knew what it was, and he told me he didn't. That's not my fault.
Right. Okay.
But I mean, if his position was, as it plainly was, that he didn't know, A, he had a defense. B, Mr. Warner, if he was aware of it, should have put it. C, it was put. And the idea that there should never have been a trial evaporates, does it not?
Well,
And moreover, I might add, President, it was properly left to the jury. Because
to be clear, to be clear, it's my position that is not the defense that was being run, and that insofar as he is saying that using the defense of duress, that he didn't know exactly what was in the package is a natural incident of that, but he was not running his defense based on that. The court, I'm invited to recollect, the real point I'm trying to make is that Mr. Davy was not trying to waste the court's time by running an unsupportable defense. And it happened that in cross-examination, because he certainly wasn't elicited in examination in chief, nor was it stated in his defense statement, the Crown asked certain questions which tended to suggest that he didn't know what was in the package, but he wasn't running his defense on that basis.
I don't understand the difference between giving evidence and whether he's running a defense. If he gives evidence that says he doesn't know what's in there, which I understand is in response to Mr. Richards' questions, what's the effect of that?
The effect is that the defendant was not trying to waste the court's time by trying to run a defense of knowledge.
But he plainly was, because when he was asked whether he knew, he denied that he knew.
Yeah, but he didn't raise it. He didn't raise it.
So what? So what? I mean, once you say I didn't know, you are ipso facto raising a defense. And if the defense is misguided, as the jury must have found that it was, you are in effect wasting the court's time.
I will say this. It's certainly a matter for the court, right? But right. In the context of the defendant running a case which was clearly destined to fail, he did not appreciate that. And had he appreciated that, he would not have put his defense. He was not setting out to tell the jury, and didn't want it as part of his case, whether or not he knew what was in the package. The question of whether or not one knows in the facts of what he felt was duress is a natural incident of that small d, large d duress. So I submit that the fact that it was elicited in cross-examination that he didn't know should not be used against the defendant in ascertaining whether or not
That's his case, though, Miss Christopher.
Pardon me?
That is his case, that he doesn't know. That's his evidence. I don't see that it makes a difference that it comes in cross-examination by Mr. Richards.
I mean, it's certainly a matter for the court. I submit that it
Right.
did, but I mean, the court is the only people that matter on that issue.
Right. Thank you.
With respect to, I mean, it's the side issue. I did send to the court the case of Frankston Privet just to show that in terms of common law arrests, it had no place in the conversation. Once there was statutory provision, and I believe I also sent to the court the page references for that, which I think is 14 to 15. I don't think we need to spend a lot of time on that, but the court will have a copy of that case, but it's very much a subsidiary point.
Sorry, which case is that, Ms. Christopher?
Frankston Furbit, I sent it, it's described as Furbit, but it's really the Privy Council case of Frankston
Pico
Furbit.
Jamal Furbit?
Correct. Which went before the Privy Council.
Yes.
And page 14 and 15, which discusses the relationship of the common law in light of the Queensland Criminal Code, which is of application to Bermuda. And simply to say that at this stage, unless we're trying to do what the Privy Council has in another case described as avoid the austerity of tabulated legalism, i.e. to interpret the code, the common law doesn't have much of a place when we have a code enacted.
Right.
With respect to Zagalis, I just referred to paragraph 22 of Zagalis.
I think we've been taken to before.
Yes, that none of these sections provide a defense in the circumstances of this case. So it is my submission that on the facts, they found that none of the sections provide a defense to the case. And with respect to the point to do with the section 29 again, I would simply say that even if the court isn't with me in connection with whether it's to be considered part of the defense case, and even if the court isn't with me, whether or not Mr. Davy in running his trial was intending to be running that, we say that it doesn't adversely impact on what we're saying about small d duress.
Right.
So in effect, those are my submissions. I don't think I can add too much.
Thank you very
that
much.
I haven't already stated.
Thank you. Well, we're most grateful to counsel for their submissions, and we'll give judgment in due course.
Okay, thank you.
The session is over.
Thank you, my lords.
Thank you.
Mr. Coelho, may I now leave?
Yes, you have permission to leave, Mr. Richards.
Thank you, Mr. Coelho.
Take care. Thank you, Ms. Christopher. Thank you, Mr. Davy. Shall we go over to the other room?